all I need. You always have good information.
Talk shoes.
Recorded live.
Hi, everybody. It's October the 4th. It's Thursday, and it's 6:15. We're a little late getting started. Well, actually, we've been started. We just didn't start the recording till now. We're waiting on a special guest speaker that's supposed to be coming on. And I'm checking now. She's not here yet. When you come on, my dear, press *8, and I will unmute you. I see U.S. Canada toll-free is on. I wonder who that is. North Georgia, let's see here. She should be coming on as Missy, but I don't see her here yet. So in the meantime, I'm having a conversation with Hailstone. Hey, Hailstone.
Yes.
So tell us again now what's going on with code enforcement and what they're doing over there. You're up in Northern California, right?
Yeah, I'm in Trinity County. Basically what they're doing is they're applying county ordinances to private property using the guise of a public nuisance. Well, if you go to the California Civil Code, I believe it's 3479 to 3480, it defines in there what a public and private nuisance are. And there's also a third one. There's an agricultural nuisance. So isn't it funny that the county's trying to create ordinances to regulate the cultivation, and their excuse is the old folks don't like the odor and da-da-da. But there's a civil code section that they could simply file a civil suit. If you grow any crop that's offensive to the senses, and it impairs your neighbor's right to peacefully enjoy his property, you can file an agricultural nuisance claim on them as long as they've been growing that crop 3 years or less, and it doesn't specify what the crop is. Oh. And so what they're doing is they're applying public nuisance, which is blocking a public road, a public trail, a public creek, that anybody can abate that because it's public. They're applying public nuisance claims to private property. And when you look at the private nuisances, which you cannot abate because you would have to violate somebody's private property to go on there and abate whatever the nuisance is. So that you'd have to take them to court and get a judgment. So, it's just such a sham what they're pulling, and they're doing it strictly for revenue.
That's it. That's everything. Profit.
Yeah,
Gone
profit.
To the extreme.
Right. Yeah, well, because the fines are $100 to $150 a day. In fact, when they first started doing the fines, they were talking about going anywhere from $100 to $500. And, because we're so rural and there's no logging anymore, there's really no industry here anymore, they decided to put it at $100. Well, now that lasted for less than a year, and they wanted to bump it up to $500 a day.
Ridiculous.
For out of compliance with their
They're
ordinance.
parasites. I mean, they're not even trying to hide it anymore. Did you see that video that's on YouTube of that, what is he, he's a congressman, getting up there talking about how everything was a false flag operation to get the war to Iraq and Iran. And did you see that one? I mean, they don't even hide it anymore.
Yeah.
It just, it was like, are you kidding me?
That one's
serious?
a couple months old, right?
And I think it's fairly recent.
Yeah, where he got up and started ranting and raving, and then they put him on the news and tried to make him look like a fool.
Oh, it's amazing to me. But hold on a second here. Let me see what we've got. A California there. Go ahead, California. You've been unmuted. Is that you, Missy?
Yes, it is.
Oh, wow. Well, if you're coming on as California, it says California here, so welcome. I'm so glad you made it.
Thanks. I'm hearing two of you.
Yeah. Oh, are you getting feedback?
Mhm.
What do you have your desktop speakers on?
No, I've got my headset on.
You've got your headset on, but your speakers on your computer must be on also, if you're getting feedback. Yeah, you're hearing me through the headset, and then you're hearing me through the online thing. You're hearing me through the headset, and then you're hearing me through the. I can't stand hearing myself. You're gonna have to remedy that, my dear.
Okay. Sheesh. Let me just.
I bet you're gotta hit the sound. You gotta adjust your speakers to not be on the computer, and usually you can click it over and make it the headset. That way.
Okay.
Well, did you call in through Skype?
Yep. Yes.
Okay, so.
And I'm on the computer as well.
So yeah, just turn the volume all the way down or mute the sound on the computer.
So you guys go talk and I'll figure this darn thing out. Never done this before.
Oh, you've never hit mute on your speaker on the computer?
No.
How to turn them down all the way? There should be a little icon. I think you've got. I don't know. You're on a Mac, right?
Mhm.
But anyway, all right. I'm gonna talk to Iowa. Ben, are you still on too? Or did you mute yourself out? You muted yourself out. All right, that's fine. I'm going to unmute Iowa. Hi, Iowa. Hi, Iowa. Are you there? I unmuted.
Yeah. Hi, dear Angela.
Hello, my dear.
Your friend that was just speaking, and he mentioned prove the injured party. How do you do that when it's the state?
Oh, there is no injured party if it's the state.
Yeah, is he still there? What would be the wording for that? Or how to address that? Anyhow, it's just more of an education question because where I'm at now is I did.
You know, you walk up to him or you put it in writing and you say, prove it.
Okay.
No, there's no special wording. It's, I conditionally accept your offer upon proof of claim. I love that. That's Gordon Hall. That's pure Gordon Hall. But I've memorized it. Bring forward the original charging instrument for my inspection so that I may remedy the matter and take care of it and get rid of it or whatever. Have you ever heard Gordon Hall?
No, I haven't. What was your last sentence?
No, I don't.
I'll have to go find Gordon Hall. Okay.
He's on, if you go to the Talk Shoe Call guide that's on the website, he's on Monday night. You can go listen to the archives. His calls are like an hour or two, and that's it. What?
Is he one that I can call in with the telephone?
Yeah.
Okay, I need to.
Well, I mean, you want to hear the archives, or I don't know if you can do that with the archives.
Okay.
But I know you can call in just like this call. His is on Monday nights. Unfortunately, he's directly opposite Dave Mack.
Oh.
Summer. But, it's unfortunately you can't take advantage of the recordings. Although there's a podcast. I don't know if that you can hear by phone or what. I could hear Missy moving around or something.
Can you hear me?
Yeah, I can hear you. Can you hear me?
I can hear you. I'm just not on the internet anymore because I couldn't figure that out. Sorry.
Oh, you got to find out how to mute your speakers on the internet. Well, that's too bad though. You can't see the chat board then, eh?
No, I can't.
Oh well. All right. Well, I can tell you what's being said on the chat if it gets interesting. It always does. But anyway, I'm so glad you made it on. I'm glad you can hear and I can hear you and everything is cool. This is Missy, everybody. Welcome, Missy.
Hi, thanks. Sorry about that.
Okay, your sound quality is a little muffled also. Are you talking right into the thing? Or?
Hello?
Hello?
Yeah, I've got a headset on.
That sounds better. That sounds good. Sounded like the bass was up too high, but I know that probably wasn't the case, but that's what it sounded like. But, so what are you going to enlighten us with this evening?
Well, I've been working with a customer where the state is trying, he's got a private sector company, and the state is trying to tell him how to run his company. So they put together an administrative hearing for him, and that's where we left off with it. And he's basically just telling him, butt out. You're not the boss of me. And I'm sure there's many other companies, private sector companies across the United States that are having problems with state entities trying to butt in and tell them how to run their business, and that they have to purchase unemployment insurance, that they have to purchase workers' comp, and they have to take out deductions. If these people are private sector, they really don't have to do anything because they're not a state entity, instrumentality, or subdivision thereof. They've made no contract to be run as a state entity or whatever. So this is where we're going with all of that.
Okay, but isn't that similar to what about when they come along and say you have to withhold, or does that's not the state, is it?
I haven't really seen that with this. Well, some states like California does have California state tax withholding. I don't know if this particular state it does the same sort of thing for the companies registered with the Secretary of State there. But just because you're registered with the Secretary of State does not make you a state entity. You're not a state-created entity.
Well, what does register mean, though, Regis? What is that registration? What does that mean if you're not voluntarily submitting everything over to the state? Why would you register with the state then?
Well, I often wonder that. I mean, this is kind of a new frontier for us, trying to help the customers on whatever. But this is a professional corporation. And so he had to get a state license and go through processing and whatever, but that still doesn't make his company a state company, if you get, what I'm saying there.
Well, how does it not? I don't know. I mean, if he got a license, he asked for permission to be in business. He's incorporated, so they're regulated by the Fed, right, or the state. If you're a corporation, aren't you?
It's a private sector, unfortunately. I mean, there is a difference. You register because of the factor. They tell you have to. And these are people who maybe have been on the line for a while and said, that's it. I really want to get out. I want to prove the fact that I am a private sector person. I'm not a corporate officer of a government entity, instrumentality, or subdivision thereof.
But isn't that the same thing? Like what was his name that he passed away not too long ago? Dixon Cannon. His
was more federal, wasn't it?
Yeah, it was IRS.
No, this is state.
May I make a comment?
Yeah.
Okay, I have a friend that does private contracting, and he's doing exactly what you guys are talking about. So basically, what the license is for, hold on, Pumpkin, what the license is for is it allows you to do state, county, or federal contracting if you choose. Otherwise, you can do private contracting, and you can also be a subcontractor and do public work but still not be subject to taxation. Now, my buddy's business, he does lathing. He's got private contractors that work for him, and he pays absolutely no taxes, no workman's comp, no unemployment, none of that, unless he goes into state contracting. So that license simply allows you, if you choose, to engage in public or state contracting.
Thank you. I understand your friend's line of work. However, as a professional corporation, just to say, this customer is a dentist, and the state is telling him that he cannot hire private contractors, that they all have to be employees, and this is where he disagrees with them, and I agree with the customer.
Well, yeah, isn't that interfering with his right to contract?
That's correct.
Doesn't the Constitution say they can't interfere with our right to contract?
Well,
I know the California one, but go ahead.
Yeah, that's what the Constitution applies to you. He's not a signatory to any Constitution.
True. But he does have the right to contract.
Correct. Well, here's a couple of things I'll share with some of the information we wrote to the state, and it's basically that his company did not knowingly, voluntarily, and intentionally elect to become a state of whatever taxpayer, be a party to the public policy of the state of wherever government, be a party to a federal or state of whatever plan of unemployment reserves, workers' compensation, and Social Security. That's all voluntary. You have to volunteer for those benefits to pay into them. Another one is D, to be subject to the power of the federal or state of whatever legislature. And E, make contributions for federal or state of wherever welfare/social benefits, privileges, and entitlements.
Can you get right into your mic? Can you put it like right up to your mouth?
It's right there.
It sounds like you're in a closet. It's muffled a little bit.
Oh, I'm sorry. Let me see if I can turn this chair to maybe face the computer. How's that?
I don't know. Say something.
Okay.
Yeah, that sounds okay. Go ahead.
Okay. Private sector workers and contractors are excluded from the taxing authority of the Buck Act at 4 U.S.C. Section 111, the Public Salary Tax Act of 1939, and from the state of whatever income tax for residents who live in this state, because that's territorial. And he's not in any territorial area within that state. So a lot of that information we got off of, about the territorial and in this state, within that state, that sort of thing, you can get from the organic laws taught by Dr. Eduardo Rivera that he puts out there on the web pages.
Yeah, he's been on the call. How's he doing?
He's doing fine, I guess. I haven't spoken with him recently.
Well, I got chewed out by somebody on Skype. Dougie is his name, not to be confused with Virginia Dougie. But he was asking me if I knew his process and, okay, recite this and tell me what this means. Like, I've got the time to sit there and try to prove to this guy that I know what Dr. Rivera talks about,
Uh-huh.
It really pissed me off, so I blocked him. But anyway, we need to have him on the call again. He's got a lot of good information.
Mm-hmm.
Teach y'all who you are in the grand scheme of things.
Yeah, under the organic laws, which is great.
Yeah.
And then we've got some more information that we submitted to the state. And it's basically that this company did not provide services, labor, or materials on land owned by or ceded to the United States of America or on land owned by or ceded to that particular state. We'll call it the state of confusion. How's that?
That works for me. That covers just about all of them, I think.
Yeah. And then there's no evidence of a known lawful duty. This private sector company has seen no evidence of a known lawful duty requiring it to willingly, knowingly, and intentionally, one, be a party to the state's public policy under unemployment insurance code, or two, be a party to the state's national plan for unemployment reserves and Social Security, for assisting in the stabilization of employment conditions under that state's codes. Three, be a party to the state's administrative act, since it's not a state agency or one of its subdivisions that relies upon the administrative record. Or four, be a party to the Federal Unemployment Tax Act, or be a member of the State of Confusion Workforce Services, or elect to make contributions, again, to the Unemployment Fund, Employment Training Fund, or Unemployment Compensation Disability Fund. See, all of these states pretty much have all these little quirks that they're saying private sectors, companies must adhere to, and really you don't. It's all voluntary. You have to elect to have coverage if you want it. It's voluntary. So,
yeah, but did you read that California political code at all?
No, I didn't have a chance to read that yet.
Oh, because that'll back up what you're saying. Most of what you're saying is in there. Yeah. But I don't know about other states. But
yeah, well, this particular customer is not in California, so I didn't want to rely. I had to go to his state's codes and do a lot of research.
Yeah.
And that's what I did, so that we were on point with what we were challenging, what we were rebutting, and what we were asking for their authority, that sort of thing. I don't know.
Where are you at with this client, and at what point? Well, where are you at this point?
The administrative hearing was held Tuesday. And at that time, because of the documents he had filed with them, they didn't think he was going to appear. So I think they were just ready to ramrod him with a default, and then they were going to go with a contempt. But he did appear, and so they had to scramble to get somebody to show up, because the original administrative hearing officer didn't show up. I mean, how presumptive is that? So they brought in the employee, the state employee, who went and trespassed on his property as the field auditor to check his business, see if he was operating with employees. How can they tell just by looking at stuff?
Well, they assume and presume, right?
Right. So the presiding administrative hearing officer Tuesday was actually, quote, if you think about it in terms of regular statutory, was judge, jury, and prosecutioner. And that's, I believe, is a pure conflict of interest, because she was biased. But she said she was not going to respond to his verified declaration of what he was and what's not, and that they would come back and probably file a suit in the state court against him. It's fine. We'll be ready to handle that. But the administrative hearing didn't make any sort of ruling against him.
So now what?
Well, we basically have filed some documents, and that's a default against them, and the notice to dismiss, because they're in default. They failed to rebut any of his stuff, and he, supplied them with a verified declaration, which they did not rebut, and therefore that's acquiescence, and verified declaration means everything stands as true. And then we filed a verified writ of mandamus, and then the acceptance of their constitutions and oath of office, and then move forward on it. So these are all things he's filing today or tomorrow.
Oh, how exciting. Are you going to let me know what happens with this? Keep me up to date on it. See how it works out for him. But, well, depending on what state he's in, if they're anything like California, they're not going to let him get away with it. They're not, well, I shouldn't use that term. See, I just did it myself. I was scolding someone earlier for using that term. And he's not getting away with anything. But do you think that the powers that be, the courts and them, are going to let him, succeed, honestly?
I don't know, because it appears that they were very confused with his actions toward them. They probably never had anybody stand up to them and challenge them like he did. And my thinking is we're putting her in a predicament that basically because she's biased, she really cannot make any sort of ruling. And because I think we have quite a bit of evidence against her because of letter writing that he did with her when she was the field auditor, telling her she trespassed and whatever. I believe
you're talking about the judge?
Well, the presiding officer. There's no judge.
Okay, all right. What I was thinking is maybe you should provide a way for her to save face in there somehow, an easy out for her that you benefit from or that your client benefits from.
Well, yeah, we can try to do that sort of thing. But, she wants to play hard-nosed with it. I guess we've got enough where we could probably try to file small claims against her in her individual capacity.
Oh, that sounds interesting.
Right, because no attorneys can appear. And if she wants to play hardball, then okay, fine, we'll go here. And then if he gets a judgment against her, then guess what? He can levy on her pay.
Yeah, but I just don't see that happening. They're like, cops. They all stick together. They all cover for each other, even when they do wrong.
Right. No, I understand what you're saying, but this is kind of heading in a new... We're using basically common law on this in their administrative hearings because he shouldn't have to be there at all. Administratively, he did say, I don't have a contract with you. And he did use some of the, we did use some of the, Dean's information, like, well, show me.
You're getting real muffled.
Okay, sorry. Using some of Dean's information, like, show me the paycheck that you gave me.
Yeah.
Where did I earn? And that was part of the affidavit. Contracts and me being an employee of the state.
Oh, I like it. Oh, gosh, I can't wait to find out how it turns out.
Yeah. We did the verified declaration of truth instead of an affidavit, based on the fact that an affidavit must be administered before a party who can give an oath, like a judge or a notary.
Right.
And my customer is claiming to be a, private sector free inhabitant.
Right. So you don't want to go before a notary or anything like that, right?
Correct.
Right. So a verified declaration of truth?
Mm-hmm. That at hearing Tuesday, she, the presiding hearing officer there, said that she wasn't going to respond to it. So we said, fine. That's, she's declaring that everything in his affidavit is true and exact. But she's not going to rebut it.
That's interesting, and she's coming right out and telling you.
Mm-hmm. So that's why we decided to move forward.
Yeah.
And it's using a lot of the information of the Yickwo versus Hopkins.
Yes. From Clyde Hyde.
Uh-huh. And, but we just found it interesting that the original hearing officer no longer is in that capacity. And that's only just weeks after them sending us the administrative subpoena juices tecum for documents. Well, he doesn't have documents because he has nothing to provide them because he doesn't have any state of state of confusion documents. No payroll stub, no contract, no employee, no nothing.
Good. I love it. And he shouldn't have to jump through any hoops to prove anything to the state or anyone else. You know,
Yep.
Everyone is his own king.
Right.
Supposed to be anyway, right? Everybody's supposed to be the king of their castle.
That's right.
Whatever that may be.
Right. And there's no injured party.
Right.
No cause of action. No claim. Just an accusation saying, you have to provide this and that. Well, sure.
Yeah, prove it. Right? Prove it.
That's right.
They can't.
No. So I know there are a lot of people out there in your audience and other people's shows that they either have their own business or have independent contractors who work with them or for them and maybe having the same sort of problems. And I hadn't really heard this problem brought up on your show, so that's why I thought, well, I'll just kind of bring it up and let people know that there's hope. We're working on it, and we think we're going to prevail on it.
That's wonderful. I can't wait. I think you are, too. When do you think you'll know more about it and the outcome? I mean, how long a process are we talking here?
Well,
I mean, it probably could go on forever if they want, right? I don't know.
Yeah, I mean, anything can go on forever. But basically, they may decide not to. Let's see, she said that since I didn't bring what the subpoena asked, that there would be another subpoena from the county judge requiring the same. Now, how does the county get in there? You know, unless they file an actual lawsuit against him.
Oh, wow. Well, you know, they've got unlimited resources to do whatever they want, right?
Well,
so
yeah.
You don't expect them to just cut their throats and give up, right? It ain't going to happen, right?
Probably not, but at least he's not giving up. The customer, he's not just going to roll over and say, well, okay, I'm going to do this, I'm going to do that, I'm going to succumb and be compelled to do whatever you say.
Good for him.
So I don't know. Do you have people there? Are there any questions, maybe?
I don't know. Anybody have a question, press *8, put your hand up, or if you're already unmuted, just speak right out. If you have a question, or our resident legal mind, Missy.
No,
Missy the mysterious.
Lawful information is not legal advice.
Oh, okay. Yeah, no, there's no legal advice. No, we don't do legal advice.
Neither do I.
Anybody have a question for our special guest speaker, Missy, who can probably answer anybody's question? No, we do. Okay, Iowa, go ahead. Did you have a question?
Hi, I have a question on default. How do you word a default motion?
Actually, we didn't put a motion, just notice that the agreed declarant moves, da-da-da-da-da.
Declared what? You're cutting out.
I'm sorry. He's not the defendant. He's the declarant because he's the agent for the company.
Oh, wow, we got terrible. She said he's not the defendant. He's the declarant?
Yes. because he made the verified declaration. So he's the declarant, not the, I don't know, is it applicant?
We can't understand you, Missy. Ooh, sounds awful, choppy and muffled, and it's bandwidth or something. It's like, that sound that happens when you're not getting enough bandwidth. So give it a minute. I just try it now.
Can you hear me?
Yeah.
Okay.
The default
but it's choppy. But go ahead. Go ahead, Iowa.
On default notice, do you submit that directly to the court, or does the sheriff have to deliver that, or a third party? How does that work?
No. Everything was done by mail.
Okay, mail.
With a verified declaration of proof of service.
Okay, can that be a certified letter? Or what is a declaration of proof of service?
Just basically, I can read the staff part of it.
We can't even understand you.
Yeah, I couldn't hear that.
Okay.
Yeah, just speak slowly.
Okay, it just basically says that he had served a true and exact copy of this legal document to and lists the various names, and he sent them certified mail to each.
Okay.
So that there's a record that he can trace.
Oh, awful. Oh, my gosh. This is terrible. Can barely understand you.
You want me to try calling back?
No, that sounded real good just then. Is that good enough for you, Iowa?
Yes, that helps. Thanks a lot.
All righty. So we've got Jerry. Let me unmute Jerry. Go ahead, Jerry.
Thank you, Angela. I was just going to suggest that she calls in on her telephone as opposed to Skype. It might work a lot better.
He came in great.
Yeah, you came in great just then. So it might have had something to do with Iowa. I'm not sure.
Yeah.
But you sound okay now.
Okay,
Thanks,
I'm
Jerry.
off.
Okay, thank you.
Yeah, getting back to Iowa's question about the motion to dismiss, I don't like motions because of the fact you're then asking them to grant what you're requesting. So I prefer doing notice of move to dismiss.
Notice of what?
Notice declarant moves to dismiss, based on,
But is it moving the same thing as making a motion?
Well, it could be considered that, because if you say,
the notice is good. The notice part is good.
Yeah, and that's what we do. The notice, aggrieved declarant hereby moves the administrative tribunal to dismiss due to having So it hereby moves instead of a motion. It's a play on words, and I think it's more people in the statutory stuff think that when you submit a motion, that they can just say, vote out, dismiss, reject. So this way, when you're giving notice of move to dismiss, it's more like you're making a statement instead of a request. I think it's just kind of the way they are.
Why wouldn't you just say notice to dismiss? Or notice of dismissal? Or why would you even put the word move in there? I'm just saying, I'm just throwing it out there.
Well, you could. That could. You could do that.
Just take it out altogether. But anyway, anybody else have a question? Press *8.
I have a question.
Go right ahead.
Is your client listed as a fictitious business under the, well, you said he's not in California, but I'm sure whatever state he's from would be the Business and Professions Code. Is he incorporated?
Yes, it's a professional corporation.
Well, aren't you going to run into problems like Hell versus Hinkle with him being incorporated, a creature of the state?
It's not a creature of the state. Again, you have to kind of go more administratively.
Corporations are born out of the belly of the statute.
But it's all the way you write your articles of incorporation. You can put certain things in there, and that's what my customers do, based on the fact that they register because of the fact in order to do business. Yeah, it's a catch-22. But in order to do business, and as a professional, whether he's an attorney or a dentist or a doctor, it's difficult working in any state or area without registering.
Well, aren't you going to run into problems as listed in Hell versus Hinkle?
No.
Well, the guy is running into problems. That's the problem, right?
Well, he's running into problems because the state obviously thinks that they're the boss of him and any other business that's operating within the state of confusion. Okay? So even if he was a sole proprietor, they would come after him and say, you can't have independent contractors, you have to have employees, and you have to do this, you have to do that. So it really doesn't matter, but it really does matter the way that you state your articles of incorporation. You indicate you are not a state organized entity, subdivision, or instrumentality, that sort of thing. You also state you do not participate in the state or federal benefits and things like that. You really have to state sort of things so you can throw it out to them and show them, hey, don't touch me. I've already done whatever. And the state's going to try to come after you, of course. But whether you're incorporated or a limited partnership or anything, even a sole proprietor, they're going to try to come in and get their money from you.
Well, they're probably most used to dealing with dentists and doctors and physicians that are receiving the public benefit programs. That's probably why they're thinking that they're going to be able to regulate him accordingly, because they're probably figuring he is receiving those programs.
Can you expound a little bit more on what you mean by public benefit?
Workman's compensation or, something to that effect, where he's actually receiving a benefit from the state through those public insurance programs.
Well, he's not receiving anything because he's not making any contributions to them.
Right. That's what I'm saying is the state's looking at him as if he is, because 90% of the people in his field, that's what they're receiving is state benefit programs. That's the whole benefit of incorporating and licensing, is so that you can receive those insurance programs.
Okay. No, he does not receive those programs. And he doesn't take any amount out from any of the people there to contribute to those programs either.
Yeah, so like that friend of mine that has the lathing business, he did get a contractor's license just so he could contract a bid on public contracts if he chose to, but he never created a corporation. So he's just a private party that deals in private contracts.
Right. And most of the companies, or most of the customers I have are like your friend is, private entities. They're not professional people that are kind of under the gun because they're licensed to do. Is your firm a licensed contractor? Do we have to go through the state's licensing contractor?
Well, he chose to. He chose to because originally when he first started out, he was doing public bidding. See, when he does public bidding, he's required to pay the taxes, like if he was going to allow the school or something to that effect. But as long as he stays private, or if another contractor receives a public contract, he can go in as a subcontractor and still be private.
Correct. Yeah. Oh, I see exactly what you're saying. Yeah. And I know from the makeup of his work and how he set up his business, he's not receiving any benefits. And he's for himself or for the people that work with him or for him.
Right, and so that's where the state's having a problem is because 99% to 100 of all the people they've ever dealt with have received those public benefit programs and are thus regulable.
Right. I know there was a worker who, now you have to understand what happens is there are workers out there who really are looking to receive the public benefits because they want to be able to go after workers' comp. Or they want to be able to go after unemployment because they're either too lazy to work or they can't find work or something. And we've already won one instance where a worker went in for workers' comp, but because the company didn't make any contributions to the workers' comp fund and no amounts were taken from the worker to contribute to workers' comp, that worker could not get workers' comp.
And he wasn't on a public, under a public contract, which would require that to be done.
Correct.
Yes. Now, my buddy's son, he actually did get in trouble with EDD and Franchise Tax Board. And basically what they did was they went in there and said, you know, they came up with like back taxes. I'm not exactly sure exactly what the fee was for, but all they did was say, who created the account? Because he never registered with them, so he never created an account. So where did the accounting come from? And basically stifled them that way.
Yeah, he did not create an account, just like most of the states say you have to register with the employment development or whatever that is called in all the other states. But they want you to get a state ID number, just like a federal ID number to run a business. They also want you to have a state ID number. Well, the state ID number basically creates that account for you to go ahead and file your monthly or quarterly returns showing payroll, this and that. Well, he hasn't done that, and there's no requirement to do that.
Now, my buddy's son, the real benefit for him is that he can go out and bid on private contracts. He can underbid the corporate contractors, and he makes enough because he doesn't have to pay any workman's comp, unemployment, and all those taxable plans, insurance scams, that he's able to pay his employee enough that if they chose to, they could take and pay into workman's comp and unemployment and whatnot. Of course, they don't. But, you know, that's the big benefit. You get all that extra money, and he's still underbidding everybody.
Right, and it's in the independent contractor saying that you know, that worker as an independent contractor is not authorized and will not receive any benefits or anything like that, including vacation time, sick days, or holiday pay, that sort of thing. But like you say, you pay that independent contractor a little bit more than you would, quote, an employee, because that independent contractor can then afford to pay those sort of things and afford those days off and do whatever. So you're trying to help them out. You're not trying to, what's the word I want to say? You're not trying to be stingy and gouge them.
Absolutely. Well, that'll definitely be interesting as him being a dentist. You know, I always think of that as as a regulatable field because of, you know, like Title 21 explicitly mentions doctors, dentists, pharmacists, and veterinarians that are subject to the code.
No, we found, I'm trying to see where the original documentation was sent. They're not. They're just basically, and again, that's what I read, shared just previously about the fact that private sector workers and contractors are excluded from the taxing authority. And they're not going after him because they're going after his workers and independent contractors. They're trying to tell him that he can't have independent contractors. They really can't tell him what to do. He's not subject to them.
Yes, that's what it's going on in the chat as we're talking about. Who is the public servant? That's one thing I learned from Dean Clifford was, who is the public servant, you or me? They hate that when you throw that in their faces. They hate it with a passion. So it's a fun thing to do.
Yes. And it's again, the public servant information is in the documents. I mean, I didn't read all the documents and stuff like that. That will be the phone here. But yeah, reminding them that you are public servants. You are state employees. I am the master. I'm the king of my castle, the king of my office, the king of my business.
Yes. Be the king of your castle and act like the king of your castle. Right?
Mm-hmm.
It's how you conduct yourself in their presence. You know, who's the public servant, you or me? Yeah. So what else? What else have you got to enlighten us with, my dear?
That's about it, because this is basically, I tried to keep it out of statutory. We just don't want to go statutory, so kept it more in common law. You know what helps is when you listen to Greg on
Greg
Saturday.
Slaughter? Oh, yeah, Greg Slaughter, the ticket player.
Right, and he has that common law default.
Right.
Packet. Well, that's pretty much what I borrowed his information to similarly do an administrative default common law instead of statutory.
Oh, he'll be interested to know that. Have you been in communication with him?
The very first part, yes, because I was trying to explain to him what the difference is between an affidavit of truth and a verified declaration of truth. So, and a couple other things. So I've just been really busy trying to keep this between my customer and look up this foreign state information so that I could help. And I'll get back to Greg on this and show, hey, look at, we can use this too. I mean, and the other one, let's see, Dean hasn't been on your call, right? He's been a no-show 4 times or something?
Yeah.
Yeah, I happened to see a video is what happened and saw some of that information, took some nice notes. But it would be nice if he...
Say what? Say that again?
Oh, I took notes from a video that I saw. But it would have been nice if your listeners would have been able to have him on so that he could share his knowledge and experience as well.
Yeah, well, I've tried, I guess he gets off at the same time we start the call. And I don't know, the last 4 times he hasn't made it. But I said earlier he was very apologetic. He Skyped me and said he's going to have to make it up to me. And he said, I owe you big time. And I said nothing. I didn't respond. I was kind of peeved, I don't like being stood up 4 times. That's a lot. And I've been very patient,
Yeah, no,
but
I
it
know.
has to do with honor, too, and integrity. I don't do that. so he shouldn't do that.
Yeah.
But I have to have him on. I'm not going to hold it against him. You know, I won't.
Yeah.
I want everybody to benefit from his knowledge, so I will have him on. Well, hopefully he'll be on soon.
Well, I want to thank you, too, because many of the times when I've been on the call listening, this is the first time I've actually participated on your call.
I know, and I'm so pleased that you are.
Thank you. I finally have something to share. But usually I'm just on the chatting with some of the other people and stuff like that. And it is interesting to note that when listening, you get through Chappie and Greg and some of the other presenters, because through them, my mind actually goes, okay, what did I learn? What did they say? Okay, I'm going to go research that. So it just kind of helps all the way around.
Yeah, I agree. It's like hashing it out. Everybody gets to put in their 2 cents, and then, whatever's good, you hold on to that. You might come up with something later on, have an aha moment. I love when that happens.
Right.
But yeah, I mean, even some people, you can't stand them. You don't want to listen to them because they're a pain, but they might have a golden tidbit in there occasionally too. So you can't limit yourself. You have to open up to listen to, well, unless they're a complete asshole, and you have some of those too. But Chippewa is saying you should have Ed Rivera on again. Yeah, I will. I love Ed Rivera. He's a good guy, I love having the good people on, the good guys. William Clark. He was a good guy. We had him on last week. Did you hear him, Missy?
The last half hour, because I didn't get your email in time, and I was still stuck at the office working on this administrative process here. So I want to hear William. And again, the little bit I did hear, I was able to do some research and say, I think I can do some of that.
Yeah, I thought it was an interesting call. Well, all of them are.
Yeah, they are. Yes, they are.
And I agree. It's good to put our heads together, even if we're not speaking at the time. When we're listening to a call, and we get into the chat and throw things out there, and sometimes some good information comes back, or triggers a thought process that leads to something that you can use. But yeah, Ed Rivera and Paul Andrew Mitchell say the same thing. Oh, do they? I don't think they say the same thing. They're two completely different guys.
Right.
Against the trustee, I'm reading in the chat. So, but yeah. I like Paul Andrew Mitchell. He's tough, but he's got a lot of good information. Bless his heart.
Yeah, he does.
He's also another one that calls himself a private attorney general. Do you ever use that terminology?
No, I haven't myself. I've often wondered about that, but I just thought, you know what? It's tough enough just trying to do this and then trying to do the private attorney general thing and see if I qualify. So I don't want to bite off more than I can chew at this point.
Yeah. Yeah, Rod Class also considers himself that, and also Kevin Michaels, and I don't know who else. But it's an interesting position to be in. I think you're giving yourself, well, you're the king of your castle, right? Whether you call yourself a private attorney general or the king of your castle. How about Bill Thornton? His way's good too. We were talking about him.
Right. I've seen some of his posts, and I've been to some of his seminars. So I mean, there's a lot to pick and choose from many of the people that you've mentioned, and it's great because it's a great learning opportunity for all of us, really.
That's it. What we learn. Can't stop learning.
No, and what we don't understand, we can look up. So I do a lot of researching. I spend hours and hours doing a lot of research before I put together paperwork.
Yeah. TJ on here is saying that Rod Class supposedly has congressional recognition as a private attorney general. I read that somewhere also. I guess he has a document from the Congress recognizing him as a private attorney general. I like that. That means he can go and help people in court and stuff, and they can't say, oh, well, you don't have a license to practice, right?
I don't know. Don't ask me. I don't know.
Well, somebody I'm sure here keeps up with Rod Class. Oh, wait. Southeast Michigan. Go ahead, Southeast Michigan.
Yes, I just wanted to inquire.
I knew it was you. Hi, Constitution Man.
Hi, how are you guys tonight? I hear you're doing great work here.
Thank you.
The problem that I see that almost always comes up now, in the old days, there used to be these guys, they were called jobbies, and what they did is
they're called what?
Jobbies, okay?
Jobbies?
Yeah, jobbies. And what they did is they would go into an engineering environment, okay, and they would literally take over the physical engineering of a product, say like a car line or some product, okay? Boeing has them for aircraft, and they're very skilled people. They're design engineering staff, okay? And what they would do is they would come in as an independent, self-employed subcontractor. They had their own tools. They would come in and set, a standard of work ethic, and, usually they'd work 10 hours a day, and they would basically produce all of these magnificent drawings that created these beautiful cars and planes and boats, and, and what would happen is the IRS would be very upset because they would come in and want somebody like General Motors to say, well, you don't take taxes out of these guys' paychecks. No, we give them their paycheck. Well, you don't, you see, and they don't like that. So what they would do is set up standards, and they would say, well, do you regulate the hours for this gentleman? And they would say, no, these guys kind of just come normally 6 o'clock to 5 o'clock. They show up, rain or shine. Sometimes they work Saturdays too. And then General Motors started getting real tough, and they said, well, no, we have to have a start time and a finish time, and we tell you what you work on. And we provide you with the drawing tables and the facility to come and do this, okay? And so then they gradually, ever so gradually, encroached on these guys' ability to be self-employed subcontractors to the point that after a while they don't hire them anymore. They just kind of went like the dinosaur. They just died. And of course, a lot of very skilled people were lost in that process. Today, a lot of these designers couldn't draw a ball bearing, and I'll set the compass for them. And the reality is you had a complete degeneration of the quality of the skills involved in producing and doing these magnificent tasks. And, of course, you saw the car lines suffer from this particular situation. And then the computer came in, and, of course, then they could just push a button and the computer would do all the drawing. You see what I'm saying? And so ever so gradually, this whole workforce of phenomenal individuals disappeared. They all went their own way. Some of them went out to Boeing aircraft out in Seattle. They basically went into whatever business endeavor they could do, and just basically walked away from drawing cars. And, of course, all the cars today look like boxes, and there's a reason for that, because they design to the smallest radius that they hold to. Your eyes normally see at 80 power, 80. Your eye sees at a certain power, okay? And what happens is you can't see the radius. So the car looks like it's drawn to four corners. So when you look at all these little cars today, they all look like little boxes. Where in the old days, these great craftsmen, you would see these beautiful templates on their boards. A lot of them would be like a beautiful woman in a bikini, you know what I'm saying? And they would take the surface lines of the body of a beautiful woman and they would put it on the car. So there was actually a love relationship between people and their cars. I mean, guys would be out there polishing their car and the beautiful. and the fenders would be beautifully fluted, you know, and they look like the beautiful bust of a woman. The Edsel is a prima facie example of that. Well, these guys disappeared because the IRS came in and tried to over-control. And I predict probably the same thing will happen to your people because they're not going to allow you to be totally independent, okay? Especially if you have employees. They're going to want you to take the taxes out of their check. They're going to want you to regulate. They're going to want you to be their enforcer. And if they come down with a lien, they want you to lien the guy's pay. You know, they're not even employees of the IRS, but the IRS has got these people suckered into being their flunky, being their collection guy. And, you know, if the IRS calls GM and says, put this guy back to zero on his W-4 and, you know, take money out of his check like he has no exemptions, okay? Mm-hmm. Now, I don't see how your guy is going to get around this type of heavy-handed tactic, you know, especially when the government wants to tax him on every stick of furniture he has in his facility. They want to come out and they want to evaluate the size, the square footage of his facility. They want to come out and tell him, OSHA, you got to follow the OSHA rules, you know, you got to have a certain safety standard, you know. I don't see how he's going to get out of having these controls. And there's another problem. The insurance companies, when you walk onto a General Motors facility, we would have to have our own insurance and prove it to General Motors, or they wouldn't let us on the floor because they're not going to have you getting hurt on their property and not be having insurance. And see, the state would require General Motors to provide that insurance so that workers' comp, if you got hurt on the job, there would be a compensation to take care of you, okay? And see, the independent contractors, they didn't have any of this kind of insurance. And so General Motors would say, well, I can't even have you take one step on my property. Now, how is your guy getting out of all of these controls and these requirements?
And you know what? The guy's a dentist.
Well, he's a dentist, okay? So has anybody ever dropped something on their foot at work? I mean, you can drop something on your foot. It's just as easy in a dentist's office as you can in a plant, you know? I mean, if you get hurt on the job, who takes care of the insurance?
Okay, I agree with what you're saying, but the independent contractor, I think it's 8 pages, the agreement, basically says that this person is going to go ahead and get the licenses, the insurance, and everything else, okay, because they're not going to receive any benefits from him because he's not taking anything out from them. He's not contributing on their behalf either.
But how does he get away with that? I mean, how does he actually able to open his doors and function? How could he make a contract with General Motors who is going to demand to have those insurances? Otherwise, you don't come on my property.
Well, maybe he doesn't want to work with General Motors, that if General Motors is going to try to enable him.
But you're going to find all of the big companies, all of the mainline companies are going to have the same insurance policies.
Right, I understand that, but we work mostly with independent small businesses, that sort of thing, because the larger businesses, unfortunately, kowtow to the state and federal demands because they don't know better. They've been told bad information by their tax professionals or whatever. The law says you must do this. The law says, no, the law does not say that. If you read it, if you are a state organized or federally organized or government organized, city, state, county, whatever, yeah, then you have to kowtow to that. But as a private sector, as long as you're not hurting anybody, I mean, the people, I've never been to his office, this dentist's office, but I know other dentists who have hired friends of mine who are dental assistants as independent contractors, and my friends go in there with their own tools. That's part of the deal, you know? You're going to be an independent contractor, you're going to bring your own tools.
I'm seeing also that your workers are actually in agreement with this contractually. In other words, they would rather have it this way so that they can get their whole pay and not be fooling around.
Correct, and that's also stated in the contract that the worker, the independent contractor, is liable for anything they want, including reporting if they want, because the dentist has no known lawful authority to be a withholding agency or required to report any payer data, W-2s and 1099, because he just doesn't. I mean, that's very, very spelled out in his contract.
I see.
Everything.
Well, I just was curious how you were going to get past those people when they pull this stuff, because they almost always get around to it, and he's probably licensed, has a professional license to be a dentist, and a lot of times they'll hold that against you, and if you don't cooperate with the state, we just don't renew your dental license, that's all.
Yeah, I think that's about the only risk that he's concerned about, which is a good risk. But right now, we just kind of want to go through one problem at a time, and that's trying to get the state out of trying to tell him what his workers or who he's supposed to hire. And he really does want to work with independent contractors and people who aren't looking for entitlements, you know.
You also get a better employee because he's there to do the job. He's there to do the job. That's, you know, I show up to do the job. I'm here to work, you know. I get paid when I do a quality job. You get paid when you sell my quality job. You see what I'm saying? So you're actually going to get a better worker that way.
Yeah, I believe so too. And he said he's had 2 people accept the terms of the independent contractor agreement, and 2 people decide to walk because they want to be able to, in their mind, they want a tax return at the end of the year because it's like money in the bank. I mean, that's stupid. But
plus, they don't want hassles from the IRS either.
Right, but if there's no reporting requirement, the 940s and 941, then there's no bad payer data being sent out because those W-2s and 1099 are gift tax forms. Again, you have to go back into the federal stuff and understand.
He doesn't file any K-1s or 1099s at the end of the year that he pays these workers XYZ amount of money?
No, because he doesn't like for Sparklets and any whatever else. He doesn't give 1099s to Sparklets and any of his other vendors as well.
So he's given up all those write-offs off of his taxes.
He doesn't have a reporting requirement. He's a private sector.
So what was it? God bless him. I mean, that's free enterprise at its core. Willing buyer, willing seller. I would think that, you know, just leave me the hell alone. I'm here, just do my job and go home.
Exactly.
Pay for my kids and my house and just leave me alone.
Mhm.
Okay, well, I wish you luck. I really do.
And thank you for your input.
Yeah, well, you know, there's a lot of chat going on saying pretty much the same thing. If he's a corporation, if he's asked for a license, he's subject to. And you're saying no because he's private sector, but I don't know. It doesn't work in my brain for some reason.
I know it doesn't work in a lot of people because they haven't been conditioned or researched this.
Yeah. Well, you know, we're brainwashed to believe that if we ask for a license, we're asking for permission, then you're subject to whatever they put over you, federal, you know, regulations and whatever codes, rules, regulations, laws.
Mm-hmm.
I mean, you know, he could jeopardize his license to practice.
Exactly, and I've already discussed that with him. And
guess he can always move to Mexico and be a dentist there. I don't know, you know.
Yeah.
But if he's got a thriving practice here, he better think long and hard at what he's doing, you know, and what the, you know, outcome could be possibly. I mean, we're dealing with criminals in the government, so, you know, God bless him. I hope you win.
I hope he wins too. Or not wins, prevails. I hope he prevails.
Yeah. Just share the fittest saying, if he is licensed, he is not private practice.
Well, again, there are just different things in the way that you set up your business. And people have looked at that. We've been doing this for years and years. And there's ways. There really are ways.
Have you ever heard of anyone prevailing at this before?
Well, this is the first time I've seen a state do this. So I'm not, this is a new realm for us.
Yeah. I wouldn't even, well, I don't know. Angela asked if he pays taxes. Does he pay taxes? No. I think he made that clear earlier on. He's not required to.
Yeah, no federal or state, personal or business.
The only people that are required to pay taxes are those employees of the government, right?
Right.
Yeah. Mm-hmm.
Title 26, United States Code, Section 6331A. Those are the only ones required.
Right. And that's why they leave the A off when they give you a notice of lien or levy.
Yeah. Exactly. Well, that's why the majority of people out there that have their own businesses, and when they talk to their tax professionals, be it accountants and CPAs, whatever, they're not really familiar with what a private sector company can do, because they've all been taught the theory and practice of IRS codes.
Yeah, it's all internal.
Exactly. And
we are not internal.
No, we're
as far
not.
as they're concerned.
We're external. We're exterior.
Yes. We're outside of that 10-mile square place known as D.C.
District of Criminals.
What? What'd you say?
District of Criminals.
Yeah, really. Pretty nasty. Okay, anybody got any questions, or would anybody like to chime in, participate in the conversation? I'll unmute you. Just press *8. There's a lot of people on the call. I guess everybody's just listening and taking it all in.
Well, maybe they're thinking, I ought to research this because it could benefit them. It's the bottom line, really, when you think about it. You don't have to pay the taxes and stuff. Most of that's all voluntary. In fact, all of it's voluntary. You have to elect to participate. And most people don't know that they have the option to opt out, to not participate.
Right. There's a lot of people on the chat saying they love you, Carl.
Thank you.
Blonde by the Light. You know who that is?
There's so many people out there, and I love them too, and I'm just trying to make sure they get the best data possible so that every little one gets their day in court. So wherever they choose to fight, they fight.
Yeah.
Now, it's interesting to note that in 1984 was the last year, I can remember this just as clear as a bell. They retired this old gentleman. He was one of the finest designers in the absolute world. You could roll his drawings out 60 yards and it wouldn't be off more than 20,000th of an inch. And they had us surround his board, and he mainly did the instrument panels, which is the closest thing that the average person gets in a car. They are forever looking at this instrument panel, so it has to be absolutely perfect. His name was Jerry Albertson, and he was just the most phenomenal designer. And I was just a young punk kid at the time, and he, come here, kid, let me show you how it was. And see, I would get his coffee and run his drawings and do all this stuff, so he put me under his wing, and he taught me unbelievable things in engineering. how to do and, handle difficult problems. And now in 1984, he was the lead at Chevrolet for their instrument panel group. And they had this big party at Mahogany Row over there at the Tech Center in Warren. And they had all the engineers and designers come around, and they had a big cake. And they said, this is the last time you will ever see a product drawn physically, to a fine artistic point. Now, what happened, that was the GM10 car, okay? And that GM10 car today is worth a lot of money if you have one, okay? It's worth a lot more than the Blue Book price, I can tell you that. That was the last car that was physically built from the first line drawn till it rolled off the assembly line, and they did that in a record time of 18 months, which was unheard of in the world. Nobody had ever done that in the entire history of the world. And now if you get one of these cars, and I saw one just sold recently, it was several $100,000 for this car, and it was in mint condition. It was just a thing of beauty. And, nothing would ever go wrong with them. They were just built to the nth. And, of course, this was all done with this work staff of these independent contractors. And, of course, they had a high ethical standard, and when they showed up at work, they drew beautiful stuff, and it worked. And you didn't have to do it 3 times over before it was right. And I can remember sitting at my board one day, and I'm drawing, and the boss came out, and he started yelling because the guys were shooting rubber bands and doing all kind of stuff. And the one guy said to him, he says, how come you never yell at those 2 guys over there? You mean that old guy over there and that young guy that works with him? He says, have you ever noticed whenever I come in here, their head's down? Have you ever noticed they're always drawing lines? Have you ever noticed I don't ever have to take their drawings back? I don't ever have to redo the job over 3 times, He says, now, when you guys get that good and stop shooting these rubber bands and playing and screwing around, maybe I won't come out and yell at you. And so he was talking about me and this old-timer that we're working on these instrument panels. And this guy was a real hard-nosed Polish guy. We called him Billy, Wild Billy the Polak, and he was just a beautiful individual, and he just demanded absolute perfection. And he was a serious engineer, and anytime you looked at any of his jobs, they all came out perfect because he just wouldn't take anything less. And after that period, everything went downhill fast. And so you notice that when people are on the line and they got to perform and they got to put out, and when they show up, it's got to work. You can't have this stuff 3 times hourly stuff. Every time you put a line on that drawing, you're talking thousands and thousands of dollars by the time we get it punched out in steel in the plant, and we can't afford to find out all of a sudden, the glass doesn't fit, or the doors won't close, ridiculous stuff. You know what I'm saying? So after they did away with those guys that were working independent like that, everything kind of went to pot after that. You don't see trunk lids sealing, you got leaks, you don't see doors closing right, you don't see windows going up and down right, you don't see a lot of things on the seats don't work right. You get in the car and I can't adjust the seat. What's the matter? Well, try adjusting it. Well, it won't adjust, You got all kind of problems. And see, this is a direct result of the staff, the quality of the staff, which was really professional, working by themselves, for themselves, and then they went to this new age, and it just turned absolute garbage. Now,
is there a case that you know of that gives the definition of an independent contractor?
Yes. Yeah, it's right in the IRS manual, as a matter of fact. If you set your own hours, if you have your own tools, if you perform your own job and you basically handle everything yourself and you pay all your own insurances, then you can be an independent contractor. But if you're not willing to do that and the company is not willing to have you on their property doing that, then you cannot be an independent contractor. So it has to be like between 2 parties. It sounds to me like this dentist has worked out his side of it, and if he's got people that are willing to agree with this contract, then he's in.
Mm-hmm.
Okay, well, that's in the code. That's in the Internal Revenue Code, right?
Right. They set the standard.
But do you, Do you have do you know of any case sites that?
I know that you have a right to work and contract your labor, your skill, and your time of life as you see fit. That's Bailey versus Alabama, 219 U.S. 219.
Okay, that's Bailey versus. Hold on, honey. Bailey, Bailey, versus Alabama.
219 U.S. 219, and that.
Wait a minute, you got skipped on. Bailey versus Alabama, what?
219.
219.
U.S.
U.S.
Page 219.
Page 219, okay.
Now, what that case does is it declares your absolute right to work and contract your labor, your skill, and your time of life. That it's a gift from God. And the proof of that is another case called Atkins versus Children's Hospital, which says that the skill of hand and brain is a gift from God. Okay?
Atkins versus Children's Hospital? Okay.
Yeah, you can, a lot of people aren't aware of it now with this Google. It's gotten to be incredible. You just go on Google and type in United States Supreme Court and then type in the case. Type in the case Atkins versus Children's Hospital and it'll just come right up. You don't even have to know the site anymore.
Atkins versus Children's Hospital, okay. That's a U.S. Supreme Court case.
That's the one that sets the standard that the skills of hand and brain come from God, not from the state.
Oh, I love that. I love that. You never hear the court say stuff like that. How old is that case?
Oh, it's old. It's old.
They don't say stuff like that anymore, you know?
Oh, they put this little typo on there that says unpublished.
Oh.
Then you can't reference these good cases that are unpublished. They don't want you to reference. Why suppose that is? Because they don't want people to know this stuff.
Yeah.
And then if you try and enter it as a case...
Whoa, what was that big noise? Whatever it was. Okay, go ahead. I'm sorry.
There's some jokers out there, I think, you know.
Oh,
anyway,
hold on one second. Okay. All righty, go ahead.
Make a long story short, you establish your right, which is guaranteed. The right under Bailey versus Alabama, the right to work, the right to contract your labor, your skill, and your time of life. Then you turn around and you show that the state has no right to convert that right into a privilege and require a license and a fee. That's Murdoch versus Pennsylvania. Murdoch versus Pennsylvania.
Murdoch versus Pennsylvania. What?
Right. 319 U.S. 105.
319 U.S. 105. Okay, and that was what again?
The state can't require you to have a license and a fee for the exercise of your constitutional right to work.
Right, okay.
Now, it further goes on and says Shuttlesworth versus Birmingham, Alabama.
Shuttlesworth
was a bishop.
We're saying Shuttlesworth versus what?
Birmingham, Alabama.
All right.
That's recorded at 373 U.S. 262. Says that if the state does arbitrarily and erroneously convert your rights into a privilege and require a license and a fee, you can ignore the license and the fee and engage in the right with impunity. That means they can't punish you. Now, the beauty of this, the absolute beauty, is that you have relied on the counsel of 9 justices of the United States Supreme Court. Therefore, you have a perfect defense to the element of willfulness. One of the major things that must be proven by a prosecutor is that you did willfully and knowingly avoid a known duty or task under the law with a moral certainty, okay? Now, if he can't perform that task, he doesn't have a cause of action, okay? So what you tell him is U.S. versus Bishop, U.S. versus Bishop 412, U.S. 346, which declares that. I relied on the counsel of 9 justices of the U.S. Supreme Court, Judge. I have a perfect defense to the element of willfulness. The burden on this prosecutor is to prove I willfully and knowingly avoided a known duty or task under law with moral certainty. And he cannot meet his burden because I have a perfect defense because I listened to them 9 justices of the Supreme Court in Murdoch versus Pennsylvania and Shuttlesworth versus Birmingham, Alabama, you see. And since I have listened to them, you can't punish me for listening to them and following their advice. So therefore, this prosecutor, he doesn't have a cause of action for which relief can be granted. Therefore, Judge, I would move for dismissal with prejudice, failure to state a cause of action. And I would kind of collect my costs and fees for having defendant's patently fraudulent and spurious complaint. And that would be Michigan Court Rule 2.116, parens C, parens 8. which basically says if you don't have any genuine issues of material fact, you have a right to a summary judgment, and they have to dismiss it. Then you turn to the judge, thank him for his very valuable time, and he will usually turn to the prosecutor and say, well, Mr. Prosecutor, would we venture a response? And everybody in the court will bust out laughing. And then the judge will go, all right, I'll clear this courtroom. I don't want any further outbursts from the peanut gallery. And some lawyer will usually bust out with, you got to get on your feet, Prost. You got to be on your feet to talk to the court. And goes, okay, that's the last outburst. I'll clear this court, you know. And then the guy gets up and he says, well, Your Honor, in light of the facts just presented, the prosecution will dismiss all charges, will issue a nolo prosequi, and will agree not to prosecute the matter. And the judge will turn and goes, there you go, son, you're free to go. And they let me go.
Oh, nice.
When I got to the back of the room, this old-time attorney said, son, I've been an attorney for 52 years, and may I tell you, sir, that was one of the finest arguments I ever heard, shot from the hip, because I know they only gave you a minute to get ready. And may I tell you, sir, you are my hero. That is absolute perfection. And I know one damn thing, when you go home tonight and drop them drawers, they got to be made out of solid brass, because you just beat the holy hell out of the Bar Association of the State of Michigan on your right to work. And we hate the Bar Association. They're a chain around our neck. And all the lawyers went, here, 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 here. And so for, you know, short of getting hoisted on their shoulders and hauled out of the court, you know, and every time I see that judge, he laughs. He looks at me and he goes, still going on? I said, just like that bunny rabbit and them batteries. And he busts out laughing again. But they've left me alone since that case. They haven't tried to charge me with practicing law without license since then.
Wow. Well, how about this? Somebody on the Fed on the chat is saying the point is that independent contractor is a term defined by the state taxing authorities. Use a different term. Voluntary implies, not imputes. The issue about full disclosure is debatable. Oh.
Just tell them you're a contractor, you know. Now we pull up Article 1, Section 10. The state cannot enter into any type of blocking on your right to contract.
Right.
Nothing but gold and silver coin shall be made a tender payment of debt, nor shall they impugn your right to contract, you see. So that's a constitutional right all by itself. Now you turn around and tell them, and the Ninth Amendment forbids you, even though you added onto the law, from taking away rights that are previously guaranteed. So I had a right before to have my right to contract pursuant to Article 1, Section 10, and you have no right to take that right away, and you have no police powers to do that under the 10th Amendment either. It's you only have the rights that we granted you, and you have the rights that are not prohibited. Well, it's prohibited. The Ninth Amendment prohibits you from taking away rights that are previously guaranteed to the people, and one of those rights was the right to work. That falls under your right under liberty under the First Amendment. Life, liberty, and pursuit of happiness. You know, a lot of times when you talk to people, you say, well, what do you do for a life work? You see, part of your life is your work. And they say as soon as he retired practically, you know, and sat in that rocket chair, after that it was all downhill. He died shortly thereafter. Well, why? Because he lost his life, liberty, and pursuit of happiness. His pursuit of happiness was his work. Are you there?
Yeah, but what if his pursuit of his work was robbing banks?
Well, it can't be where it's harming somebody, because then he would be infringing the other person's rights.
Right.
So it stops at the other fellow's nose. Your constitutional right stops at the other fellow's nose. As long as you respect that mark and that line, and you don't punch him in the nose, and then he doesn't punch you in the nose, you have your right to be a king in your own right, and he has the right to be a king in his own right, and everybody's happy. But as soon as you want to go punching him in the nose or stepping on his toes or impugning his rights, then we have a problem. We have a conflict.
Yeah, there's.
Go ahead.
Okay, now I have access to FindLaw and a few other law sites, and I did look up a lot of things about independent contractor versus employee, that sort of thing. And one was very interesting, is that basically the parties agree that the contractee's work enhances the entity's business and is not vital to keeping the business running. The contractee shall provide reasonable effort to the assignments consistent with the stated goals of the entity. However, the entity accepts and agrees that the contractee does not guarantee nor warrant any particular result. But that's the small thing. The contractee enhances the entity's business.
Right.
Mm-hmm.
Because he has to deliver, and he has to be skilled, and he has to actually do what he says he'll do.
Right, and it says contractee B. Contractee has specific tasks to do, and failure to satisfactorily complete them may result in non-payment. The contractee shall provide periodic written reports to entity or as frequent as necessary or subsequently agreed upon. So, I mean, there's a whole lot of things, but we went and
worked in medical offices. You have to fill out all these charts. I mean, they're doing that. I mean, the people that are working in a medical office or a dental office are going to have charts. I mean, when you come in, they pull your chart, you know. So I'm sure there's some merit to that there would have to be some type of report, something that says we're making progress.
Mm-hmm.
This the Fed on here is saying you should use the term private contractor instead of independent contractor, I guess. I don't know. We're all private contractors, aren't we?
Yep.
Really?
Some are better than others.
True. So what do you think about this, Dennis, trying this?
I think he's got a lot of courage.
Yeah.
Yeah, I do too, and I applaud him because, of course, he has access to other professionals, not only other dentists, but other doctors and whatever. And he's running risks, but I applaud him and I respect him for that.
Well, he's got a lot of courage. There's definitely courage. There's other problems that we haven't brought up here. He also has a special license to issue prescription drugs, okay?
Yes.
And what states like to do is they like to come down and they like to jam the medical professional on his ability to issue scripts, okay?
Mm-hmm.
They make him jump through his ass and fill out triplicate charts and all this stuff about who's getting what scripts and why, especially if it's class 4 narcotic, okay? So what happens eventually is if they get pissed at a dentist or a doctor, they can withdraw that license. Now, I just pulled your tooth and you need painkiller. Now, how do I get you painkiller? If they pull my license to issue you a script for painkiller, you know, you're in a lot of pain going home here, you know?
Exactly.
All of a sudden you start realizing you cannot take in clients and pull their teeth without painkiller, you see. So otherwise you're out of, and of course after the people realize that, you're not going to have many clients that want to have their teeth pulled without painkiller, you know what I'm saying? So it's a vicious circle on how they control and how they try and wangle their way into some type of adhesion contract to hold you. And see, they do that to paralegals. It's the same thing, which is why I didn't get a bar license, because I will not have some guy come into my office and tell me, well, you can't help this guy. Why not? Well, he's going against the state. I don't care if he's going against a man from Glad. If I told him I'm going to help him, by God, I'm going to help him. So then it's like, well, if you go against him, they'll pull your ticket. Well, they're going to have a real hard time. I don't have one of those tickets, you see.
Mm-hmm.
I was actually offered by the dean of a prestigious law school, because I passed the bar with almost 100% correct answers. He would get me my bar card through the state. He would use his influence, and all I had to do was provide 3 character witnesses that I was a person of excellent or good character, and that he would actually speak on behalf of me because I passed his really hard bar exam with almost 100% correct answers. I had the highest grade in the whole class. And he said, I will vouch for your knowledge and your training. The problem is that the state will have to make the final decision on whether they will allow it. But we will certify your training level, and we will certify, and you give us 3 affidavits from, character affidavits from 3 witnesses that will testify to your fine character, and then we'll just have to see if the state will honor that. And I told him, I said, Father, I really appreciate you doing this for me. I know that, you don't just give out this type of educational opportunity to everybody coming through the door. And I want you to know I'm very grateful, but I cannot take that license, because if I take that license, then they can come in my office and tell me, well, we don't want you to defend this guy. He's going against the state. He's suing the state. And if you do take this case, we'll pull your ticket, you know. And see, I'd be inclined to want to toss you out of my office real fast. Get the hell out of here. Don't come in here bothering me, telling me who I can and who I can't help. That's my business and none of yours. Now get the hell out of here. Go on, go. But see, a bar card licensed attorney can't do that. Because he's got family, he's got a mortgage, he's got all this stuff. You know, if he doesn't do exactly, I've actually seen attorneys called in the back room and that you could hear all kind of yelling. And when the attorney came out, he says, under the circumstances, Your Honor, I will have no other choice but to withdraw from this case as ineffective counsel, and at this time I submit my resignation. And the judge goes, I'm sorry you feel that way. I didn't think we needed to go that far. But obviously the judge had threatened this attorney, and he wasn't having it, so he bailed. And he walked out, and that forced them to have to shut the whole trial down and get another attorney for this guy because they couldn't go forward with the trial until they got him another attorney. And that pissed the judge right off because that ruined his docketing schedule. But then they shouldn't have threatened this guy. This guy was obviously a person of character and integrity, and he wasn't going for it. But it does happen. I tell you, honest to God, I've seen it myself, personally.
I have seen it as well.
There's a big problem when you're talking about professionalism and you're talking about ethics, and that we're supposed to be functioning under the law.
One of the other things, I'm looking over the independent contractor agreement that my customer has now. We did specify non-covered status, D, whereas the parties agree that no common law rule of master-servant relationship exists. Entity is a private sector, non-statutory establishment. The entity is not a statutory withholding agent and has no known lawful authority to deduct or to withhold amounts from pay for federal or state unemployment insurance, federal or state income tax withholding, Social Security contribution, or work compensation. Entity is excluded from creating federal or state government forms for reporting private sector amounts paid to each contractee. I mean, that's one of the provisions. We have tons of them.
Well, this is kind of what that gentleman did down in Texas. He had a plastics plant, and he actually told the government that he was not a federal agent and that he did not choose to be a federal agent and that he wasn't going to be a quasi-federal agent and he wasn't going to be a collector of debt, a third-party collector of debt for the federal government, and that from now on he was going to honor whatever the people wanted in terms of their relationship on their W-4, and if they didn't want to submit a W-4, you know, with what their tax status was, that was their choice. They would have to deal and live with the legal side of that. And then he refused to cooperate with the IRS and do any further tax collecting on behalf of the government. That he, you know, if I went out and told you that I was a federal agent or if I impersonate a federal agent, you'd put me in jail for that. Yet you're telling me I'm a federal agent and I didn't even tell you I wanted to be a federal agent, you see. And so we got the case called the Merrill case, which says one who enters into contract with the government must make certain that he is within his legal rights and authorities, and that if anybody gets injured in the process, he's totally liable for that injury. So when the government comes out and tells these employers, well, I want you to take his whole check and put him back to zero, you know, on his W-4, and we want you to deduct XYZ amount of money out of this check every week now, and they do this over the phone. They don't even send the paperwork anymore. They're so lazy. And when these businesses do this, they don't realize that they're 100% liable for any injury to that employee.
Yeah, exactly. Well, another one of the provisions is contractee declares he or she is not an agent or officer of the state or a subject of any government. The contractee declares he or she shall not perform services as an agent or officer of the state or as a subject of the government, and the contractee declares he or she shall not be paid as an agent or officer of the state or as a subject of any government.
Well, that's another big joke. You see, they're getting these businesses to do this for free. Now, in your mind, can you understand what kind of a businessman that's got a multi-million-dollar layout here is willing to risk his whole company by going and screwing with this little worker here just because these guys call up on the phone and say, go ahead and screw with that guy, it's okay. We tell you it's okay, okay? Or we tell you he's got a notice of lien. And by the way, a notice of lien is not a lien within the meaning of the Internal Revenue Service. You've got to have an actual levy. When you look at a form that's an actual levy, it's a Form 668B as in boy, not a 668WCS or ACS or any of that other. And it says right on it, lien levy. It doesn't say notice of lien. It says lien. Now, what they're doing is they're interposing this notice of lien. And they're telling people, okay, withhold from his pay. Well, wait a minute now. Where's the lien? And the lien is supposed to be signed by a GS-11 collection branch manager, and that's right in their own rules. And see, they're letting these revenue officers, these agents that are nothing but a GS-9 sign the thing. And then if you look in the lower left-hand corner of the thing, they have one person's name put down, and then they have a little for, and they have another person's name signing for that other person. Okay, what's the power of attorney for them to sign? How can they be a TTSC trustee if they don't have a power of attorney that gives them permission to sign for the person? Now, how do you record such a document? It's not supposed to be recordable, but it's recorded all the time, and they're actually putting liens on people's property. They're actually taking people's paychecks. They're actually going into bank accounts and taking it all on this notice of lien, which is 100% illegal. Totally illegal. It is not a lien.
Correct.
This to the employer, he sits there going, well, we're seeing we got a lien. Well, you're a foolish child. Now, let me show you what one really looks like. And I hand them the real one, and they go, oh, it is different, isn't it? Uh-huh. And if you go forward on this, you injure this party, and you injure this party in an irreparable fashion, guess what? You have not one defense, not one. Now, I highly recommend you take this kindness on my part to inform you of this, because it's not my place to inform you. You're a big boy. You put your pants on, same way I do. I get a time. And you're supposed to know what you're doing, you see. And see, you don't know what you're doing, and I'm trying to help you avoid a major legal problem, which you don't need. And you're sitting here like a stick in the mud, and you're going to play games with me and take my pay on this notice of lien. Now, go look at your Internal Revenue Manual. You'll see there's plenty of cases that hold that a notice of lien is not a lien within the meaning of the Internal Revenue. They had no life and casualties lenders, a bunch of others.
Yeah.
So either you pay attention, and we have a letter. We got it to you, Angela. It's called the Pastor there tonight. Pastor Garth letter, okay? And when you read that letter, it explains exactly what's being done, exactly. And when you explain that to most people that work behind the desk of the records and deeds office, they'll look at it and they'll go, oh, I didn't realize there was such a difference. Well, yeah. And I said, now you got your oath and you got your bond on the line. And if you don't do the thing right by the book and be square deal, people can attach your bond. Now, if they attach your bond, you're not going to be working as a clerk in this register and deeds office anymore. You're not bondable, and there's no bonding company that's willing to take the liability. Once you get blown off and they pull your bond, you're screwed. So you need to think real carefully here what you want to do. And I recommend highly you just take all that notice of lien off of my property and leave me the hell alone. Now, if you happen to get a lien, okay, we'll sit and talk. But until you do get a lien, you better not put a lien there. Usually a smart clerk will immediately realize, whoa, this guy's being nice. He cut me a lot of slack. I think I'll just pull this lien and we'll just forget this. And then I said, when the IRS comes in, you tell them, I want to see a court order signed by a judge of a court of record, or I want to see a lien signed by a GS-11 collection branch manager or above. Now, you provide that and we'll file it. Other than that, have a nice day.
Somebody's asking you here, do you know of anyone who has ever filed a suit on an employer for taking of funds from employee from notice from IRS, from a notice, I guess earnings withholding order?
All kind of people have done it.
And have been successful?
Yeah.
But you don't hear about them very much.
No, you don't, because they try and keep it unpublished. They try, and then what will happen is it'll get quietly settled, and you'll agree as part of your settlement not to talk about this. Because if this stuff gets out, it goes across the country on the Internet like wildfire. But one of the people that actually did it was that gal who was the airline pilot for
Oh, Bernie Kuglin.
Bernie Kuglin. There's been a lot of others, too. People versus Long. Long won his case.
That's right.
There's a lot of people. That lawyer, he just died recently. He won his case.
Yeah, Tommy Cryer.
Tommy Cryer, that's the one. There's all kind of people. I've won several of my cases. They don't even want to talk to me anymore.
Whitey Harrell. Oh, no, that wasn't a withholding order, though. I don't think. Was Whitey Harrell, didn't they take him back to court recently? I don't know.
They're going to harass you into an intimidation factor if they think they can. But if you stand strong and you know your shit, and the bottom line is they look like they're going to get the hell beat out of them, their boss is going to pull the plug and just tell them, look, let that one go. There's 99 million others we can grab. Let that one go. And their attitude is they can find something wrong with 100% of every one of these returns. That's their attitude. The law is so...
Uh-oh. Where'd you go, Constitution Man? Where'd you go? Oh, gosh.
Yeah, we lost him, I think.
Yeah, I think so. Let's see. He comes in as Southeast Michigan. Yeah, we lost him. Hopefully he'll come back on. But, what's on here? Let's see here. North and West Colorado. Oh, sorry, Nancy. Did you want to talk to him?
Yeah, I wanted to talk to...
Constitution Man.
Yeah, I kind of wanted to ask him, you see, about the secret lien that arises with the notice of tax lien. And where it is.
Yeah, well, the thing is, though, they never provide it.
Well, I know.
They don't want it on the record, so they're hoping you're not going to mention it. They just come up with the notice of lien. Right, Missy?
Yes.
Yeah, but where could you find the secret lien or even prove it so you could say that this was fraud, that they didn't...
Well, it's in the congressional record. I mean, I've got it somewhere, where it says, that there's a mortgage on everybody and their children.
Well, that doesn't mean anything. I would say you can go to the district court in your area and see if there's been a lien filed against you. And it's part of what Chappie talks about.
Yeah, but it's not the district. It's not. There are two different courts, and he hasn't made it very clear because it's a federal tax lien. So you have to look in the federal district court, not the district court in your area.
Well, I understand what you're saying.
Yeah.
And the other thing I would check would be, because the property is actually state, why not check the Superior Court in your state, in your area, to see if anything is filed, and then do the UCC check to see if they filed anything there. So you have 3 places to check to see if anything exists, and you probably won't find anything because it doesn't.
Well, wrong. I found every time they have filed a notice of tax lien with county recorder, they have put it in the state as well.
Wait a second. Who's put it with the state?
But
the IRS?
Yeah. They file it as in the
recorder's office.
Oh, a state will do that. I've seen that too. But I'm just saying that the state has filed it somewhere, and the IRS should file. I mean, they only file it in the county recorder's office. I've never seen it in any court. The notice of lien. There's no real lien that exists.
They have it in the Secretary of State's office.
I have never seen one there.
Well, I'm telling you, I have.
Well, you're
and
the first.
I have them, and I can print them out and show you. And I can also show you, and I found this, Angela, and if I ever get my scanner up, I found that the IRS is doing their own stamps. And and I took it to the post office. And
but that's just like somebody's saying in the chat here. That's still a notice of lien, right? Not a lien. It's a notice of lien, right?
Yeah, there's no court-ordered lien. I've never seen one, unless, whatever, but in the majority of them, 99% of them, there's no court order. And that's what I'm saying. Go to the different courts, the federal and the state, and do a search.
Well, I have, and you're right. They don't have a court order on the notice of lien, but I want to know about the secret lien and what effect that has.
Well, it's called a secret lien for a reason. You can't.
Because it doesn't exist.
Right.
But they must do it for some reason.
Yeah, to defraud.
Go ahead, Constitution Man. You're back. Glad you made it. We didn't know what happened there for a minute.
Well, they blew me off, but I'm back. Stop a Ranger. They're highly motivated and highly trained. Anyway, it's secret only because they don't tell everybody what they're doing. See, you don't normally get this kind of data. You wouldn't get it unless you were listening to Angela's program here. So the average person out here in TV land is not aware that this is even going on, that they're actually pulling this stunt so that they could even object. They just assume, well, we have a lien. And if they call down there to the Records and Deeds office, they'll actually tell them, well, we have a lien, because they actually believe they do have a lien, but it's not a lien. And once you show them the real lien and that they don't have one of those with your name on it, oh, there is a difference, isn't it? Oh, yeah. But see, they're getting away with fooling a whole lot of recorders clerks doing this with the notice of lien, and a lot of people are victimized by the fraud.
Right. They should be putting it in a separate index because it's not an actual lien, just like you explained.
And they shouldn't be allowing them to file it as it is a lien.
There's a person, let's see, I hate to say person, SPC PJ7 is saying if the lien exists on everything, then they can't use it for special application to a tax obligation. No nexus to the tax event alone.
Well, here's the problem. And the IRS does try and cooperate a little bit. Let's say the bank had a first lien on the property, okay, because you got a mortgage from them, okay, so they would have first lien holder status. What happens is the bank goes to the court and asks the IRS to waive their first status position. And normally the IRS to cooperate with the bank so that the bank doesn't get totally scalded on this note, they'll usually back off and allow the bank to take the first lien status so that they can foreclose, okay? But that's one of the procedures in the foreclosure, that they actually appear in court, that they actually ask the IRS for permission to go ahead of them in the lien holder status because they were the mortgagee giving, they were the ones that were actually doing the mortgage on this house, and that they need to foreclose to get their funding back, or to at least be able to sell the house and try and recoup some of their loss. So the IRS will cooperate with the bank. But there's actually a procedure for them to go to court and actually ask permission of the IRS to step out of their first lien holder status, because normally the IRS takes first lien holder status even over the bank.
Yeah, I've seen documents where actually the IRS has got the bank to stipulate that IRS can be first in line. And then IRS deals. And then if there's anything left over, guess what? The bank can have it. But I've seen those stipulations.
The reason they do that is so that they don't piss off the bankers and have all the bankers on the IRS's throat, because they're trying to keep, shall we say, cooperation going between the IRS and the banks, because the IRS wants to be able to call the bank up and say, hey, pull that guy's accounts, and see if the bankers get his head of steam up, and then they tell the IRS, well, give me a court order. See, that screws their operation. So the IRS and the banks normally cooperate. I'll tell you something else that a lot of people don't know. The Records and Deeds clerks actually have classes, and they have the IRS come down, and they show the IRS how to perfect their liens and claims against people's property, and I know that for a fact. I've actually had one of the clerks explain to me and show me the booklets that they use to train the IRS on perfecting the liens so that they can lien people's property and do it right.
To file real liens without the court order?
Yeah. And so what I do is I tell businesses, I say, look, here, I'm gonna do you the greatest favor in the world. I'm going to get you totally out of this. Why should you put up all your money and your interest in your business and take the total liability for being the collection agent for the IRS? Why would you want to do that and then leave yourself liable for their doing the process properly? Well, what happens if they don't do the process properly? You're putting up your whole business as collateral for their and taking the whole risk. And also, you're not getting paid anything for doing this. Why would you want to do such a damn fool thing?
And the IRS isn't going to provide you with lawyers and assistance and information. They aren't going to do that for you at all.
Well, they told me to do it. I was following my instructions, and I tell them, they said the same thing in Nuremberg, but they still hung all them guys. I was just following my orders. Well, guess what? They hung all them guys. They were just following their orders. The bottom line is you lose your business, you get sued, they get your whole bank, and now the bank is called something else, Smith Banking, because you lien Smith's property, and now he's the owner of the bank, okay? And you get fired the first day he takes command as CEO. So, I tell him, be smart. Now, here's the smart way to do this. All you have to do is to tell that IRS agent, please provide me with a copy of an original signed order from a court of record by a judge of a court of record, garnishing this party's pay, and I'll be happy to take whatever is required, But until I have that court order signed by a judge of a court of record, I said, I can't take an action on a garnishment without that proper authority. So who are you going to give me that's going to be equivalent to a judge of a court of record? They said, well, we'll give you a collection branch manager, GS-11 or above. That's kind of like a judge. No, it's not a judge, because if it was a judge, it would say judge after his name, you see. And what if this person doesn't come under the jurisdiction of the IRS? Then what would a GS-11 or a GS-111 mean? It doesn't matter, you see.
How do you know he's a GS-11? I can't find. Because
look up the term collection branch manager by automatic status. The GS-11 is a pay grade, okay?
Yeah, I know that, but I can't find if the person who signed this is a GS-11.
Well, what you'll see is that right after their name, they put revenue agent.
They say...
See, revenue agent, that's automatically a GS-9 pay grade.
It says revenue officer.
Yeah, well, that's a GS-9.
Oh, okay.
They don't have the authority to sign it. Nor do they have authority to sign a notice of intent to levy or a assessment. They can't sign an assessment either. It has to be a GS-11 collection branch manager again, and they do it all the time. Now, there's a court case called Western Trading Company versus United States, which says if you haven't been properly assessed, there's no tax due and owing. It actually says that right in the case.
Which case is that, Western Trading?
Western Trading Company versus United States. Like, again, you go on Google, put in Western Trading Company versus United States, and it'll just come right up.
Okay, thanks.
Is the 668B, is that levy or lien?
Levy is what it says right on the face of it.
So what is the right number for a lien?
Well, it's about terminology. They never made the lien. They only made the levy.
And I have also Title 27, isn't it?
It's under 27, which is tobacco, alcohol, and tobacco and firearms. Now, are you in any capacity in alcohol, tobacco, and firearms? Well, no. So how would you even affect and attach this to me? You see, and I argue that all the time, and they don't want to go there. So
well, I've argued that too, and they just keep saying that's a frivolous argument that's been decided before.
They ordered the marshals to remove me from the building. That's what they did when I brought that argument up. And then I told the attorney, I said, you must have a really, really good attorney. And he goes, what? Why do you say that? Are you threatening me? I said, no. I said, the Honorable Horace R. Gilmore, Chief Judge of the Federal Court here across the street, ordered me to be here today to have this meeting. I'm going to have to go back to him and tell him that you told him to screw off and die. You wasn't holding the meeting, and you removed me from the building by order of the marshals. And I says, he's not going to be a real happy camper. I said, you must have a very excellent attorney. And he goes, well, now, let's not be hasty here. And we sat down, and we worked our differences out. He hadn't bothered my guy since. And I didn't get actually kicked out of the building, and the marshals apologized for me. They were just doing their orders, they said. It's nothing personal. I said, well, fine. Just make sure that if you injure somebody, you understand you can be sued. So they all know me now. It's hard to even pull stuff anymore because as soon as they see me, they just, oh, shit, here we go.
I got a couple of people in line waiting to ask questions. Can is that good for you, Nancy?
Yes, thanks.
All right, we're going to go to Make Me. Go ahead, Make Me. That's a cute name. Maykme. Did you have a question or want to make a comment? Oh, Make Me. Maybe you have a mute button on your phone. That needs to be undone. Otherwise, I'm going to move on. Oh, they're gone. Okay. Gigi Boss, what happened to you? You had your hand up. Did you still want to ask a question? I just unmuted you and you muted yourself back. Oh, no, she's gone. Oh, my goodness. Funny things happening with the talk show. Oh, well. Hopefully she'll come back. Both of the people that had their hand up got booted. So I don't know. Where's California? Missy, are you still with us? Oh, there you are. Okay.
Yes, I'm here.
Okay, good. Well, I don't know what happened to our people with their hands up got booted. So, anything else you want to add? Otherwise, we can close out the call. We've been going 2 hours. Oh, there we go. Gigi Boss.
Oh, okay.
There you are. You're back.
Okay, good evening. Hi, Angela.
Hi.
Hi, man. I'm sorry, I'm driving. Call dropped.
Oh, gosh. Be careful.
Okay, I'm almost home. Okay, I have a question about it's pertaining to how to state a claim, in a lawsuit. And, I want to know from you, Constitution Man, when someone tries to dismiss your motion on under 12b-6, I'm trying to get a perfected understanding, a really good understanding, concrete understanding on how to state a claim.
Okay, here's the thing. So that we can explain to folks that may not be aware, 12b-6 is a federal rule of civil procedure, Title 28. And what it basically is a motion for fraudulent pleading, okay? And basically, they're arguing that you don't have any genuine issues of material fact. Therefore, the court should not waste the court's time further and actually enter a summary judgment against you for failing to state an actual claim under the law for which the court can have authority to grant you relief. Now, this is done arbitrarily a lot of times, especially against people that are pro se litigants or that are constitutionalists. It's done deliberately to cut you off on a procedural matter that you may not be aware of. But the real argument is under Haynes v. Kerner, 404 U.S. 519. And what it basically says is...
Can you say that again? I mean, you're really faint. I can barely hear you.
Haynes v. Kerner, 404 U.S. 519. The test before the Supreme Court is not whether you're an attorney. It's not whether you write magnificent legal papers with excellent legal syntax. The test is whether you got an opportunity to be heard and present your case in chief. Now, what that basically means is you got your day in court to say your piece, okay? Most of the time, they don't want you to say your piece because they know you're right. So they pretend this game that you're not an attorney, you're just some little schmuck out here in TV land, and that they don't have to listen to you, and they don't want to listen to your diatribe of all the ways that you've been violated and all this stuff. But see, the court's duty, the sacred duty, to quote Howard, they have a fiduciary duty to give you your day in court. And failing that, they can be charged with a injury to you and a denial and a failure to provide their fiduciary duty. Now, they think that they're immune okay? And it used to be that way. It used to be that they were immune because all you had to do was say they were in good faith doing their job and they were in good behavior. But see, if they're denying you your constitutional rights, they're not doing their job and they're not in good behavior, are they? So the situation is that the Supreme Court ruled in two cases, Owens versus the City of Independence and Maine versus Thibodeau, and they're recorded at 100 Supreme Court. 1398 is the Owens case, and 2502 is the Thibodeau case. Now, these people were totally violated, and their rights were absolutely trampled, and they got all the way to the Supreme Court, and the court ruled, hey, you guys are judges. You're supposed to be experts on the law. You're supposed to advise us to the law. You can hardly claim that you acted in good faith for willful deprivation of basic constitutional rights because that's unlawful under Title 42, 1983, 1985, and 1986. So you were not in good behavior. Therefore, you injured this party in your individual capacity. So a suit can be maintained against you, and you don't have any immunity for violating somebody's constitutional rights. Now, this went further on in the case of Hafer versus Malo, which is recorded at 501 U.S. 21. And it basically says if you injure somebody, they can come back and sue you in your individual capacity, okay? So there's three cases right there that will help you come back if they keep denying you your rights. But the thing is, at Title V, under the U.S. Code, and you want Section 706, it's a lousy 2 pages. I recommend you read it 10 times. And you'll read those 7 planks. And one of those planks is if they deny you due process at any step of the procedure, they got to do the whole thing over again. You get the whole trial over again, de nouveau, which means it's the French civil law that means the whole thing has to be completely retried, okay? And if you demand that, they have to give it to you. So when you get hit with these summary judgments deliberately to just shut you down and keep you from getting your day in court, you have to object to that first. Ask for a rehearing on the matter, and ask that they consider the case of Haynes versus Kerner, 404 U.S. 519, and say, I have yet to get my day before the court to tell my side of this case. And I'm demanding that I get my day in court under the First Amendment. I have a right to have my case heard in court and under the Sixth Amendment. And I have yet to have that heard. And you guys just want to come out here and make every excuse in the world on some technical merit argument that I don't get my chance to tell my side of it, but you let them tell their side of it. Now, there's something wrong with this picture here. Are we going to fix this, or am I going to file suit? What do you want to do?
So does the case, the sites that you just mentioned, is that can overcome these motions?
That will shut that motion down so fast you will not believe it. Then the judge will go, she's got a point. Let's give her day. Okay, I'll tell you what.
Okay.
If they have enough time today, what they'll do is they'll set up and they'll sit down and they'll let you get a chance to present your issues and see if you do have any genuine issues of material fact. And see, when you go through your case, you put down everything that you believe is a fact. Now, when they denied you your due process, isn't that a fact? Well, yeah. So I do have some genuine issues of material fact. When they stole your property or foreclosed on you without proper cause, you do have some genuine issues of material fact. When you bought your property and you've been paying on it for 25 years, there's certainly some genuine issues of material fact. You've been paying every month for 25 years. You know what I'm saying?
Right.
So you just start adding up all of your facts and see there are genuine issues of material fact, Judge. And the only way they can get a summary judgment is if there's no genuine issues of material fact. And that's why they pulled this 12b-6, Judge, just to technically get away from having to answer to for what they've done. Now, if you present the thing in a proper and, simple, straightforward manner, I would say that the court would have to give you a listen. If they don't, is that your final appealable ruling, Judge? And he'll say, yeah. And I'll say, fine, then I'm giving you my notice and claim of appeal, and we'll see what the next court of appeals says about that. Now, the higher you go in these courts, the more professional it gets. At some point, some judge is going to look at this and say, well, you didn't even give this woman her day to present her case in chief. Obviously, there's a violation of Haynes versus Kerner here. Obviously, we violated Title V, 706. We're going to have to give this woman a complete new trial over again, de novo, because that's what the law says, you see. And that's how to overcome summary judgment crap. But they do this all the time. And they hope that you'll go in there and swing wild, just like somebody out there with their punching bag in their face, and they're just swinging wild, and they can't ever get their past go. You know what I'm saying? And see, they plan to do this, and you're stuck because you can't find an attorney that's got enough hair in their ass to go and do this job, except in very exceptional cases. So you're stuck with having to be your own attorney. You see, that's the problem, and you don't know these dirty tactics that they pull on you. And so you're stuck having to go around and around the mulberry bush, monkey chase the weasel on this stuff.
Mm-hmm.
The problem is there's a bunch of flim-flammers out here that claim to be knowledgeable, and then you go to a meeting and you run into one of these jokers, and we won't give any names tonight, but I think a lot of people know who some of them are, and they get you further down the path and in deeper trouble, and they tell you stupid stuff to do, like don't show up in court tomorrow, but show up the next day. Well, gee, what's going to happen on the next day? Well, they're going to have a benchmark for you, and they'll just put the net right over you as you come through the door. Now, who would tell somebody that's such a stupid thing to do? Well, I can tell you who would tell you stupid stuff like that because I heard them with my own ears. Okay? But you got to watch what you listen to in some of these meetings because some of these people don't have a clue and don't have a clue they don't have a clue. And they give very bad counsel, very bad. So you have to have somebody who, one, is an honest person, somebody who cares about you, somebody who will try and get you some help, and not just some BSer that wants to get a check in his hand to go out and pretend to be your friend for a few days while you get screwed over in a court.
Somebody on here wants to know where your Montgomery Ward versus Glacier case. Do I have that? Is that in all your stuff that you sent me?
Part of the problem is we had a fire, okay, and the fire went place to the ground, and a lot of that stuff was lost. Now, we know where there's a repository for that case, and we're trying to get that person to copies of it. As we speak right now, I talked to the person today, okay? So when we get it, we'll be happy to do it. But if you go and ask the court for it, they're obviously not going to help you get that case. What they will do, if you made a personal trip down to the 52nd 3rd District Court and walked in and told them you wanted that case, you would just get a wry smile. That's what you would get. And then that clerk would just temporarily step away, and you wouldn't see her again for another couple hours.
Okay.
You think there's a few ammo to blow them up? You got to quit smoking that stuff. It ain't no good for you. They're not going to help you. That was it. And they didn't publish it. But everybody in the whole town knows about that case. There were people going into the Records and Deeds office with 2 50-pound bags of coffee beans, and they were trying to pay their property taxes with a bean to the dollar. I can remember this one elderly lady walked in and says, "Do you have a young man to help me? I have 2 50-pound bags of coffee beans in the trunk of my car, and I want to pay my property taxes." And I can remember the guy who was the head guy there going, "Oh, no, lady, you ain't pulling that shit down here. You may get away with that in Judge Sheehy's court, but you ain't get away with that here."
Yeah, we tried a whole bunch down in, it's a Michigan case.
If anybody, I could get it. I could call up Judge.
They won't cut loose with it.
They won't cut loose with it, no. And you can understand, Judge Sheehy was clearly embarrassed. He come up next to me in the bathroom, and we're both going to the top, yelling at me, "You set me up, you set me up. It had to be you. You're the only one smart enough to pull a stunt like this, da-da-da-da-da. And you set me up." He said, "I'll never forgive you, da-da-da-da-da." And I says, "Judge, I don't have a clue what the hell you're talking about." He goes, "The coffee bean case, that coffee bean case. The Wall Street Journal came down here with a whole camera, the Landmark Michigan Court Division, the money of accountants, coffee beans. Are you trying to get me killed like that Kennedy guy?"
Gee, do you think if we wrote to Wall Street Journal, we might be able to get it?
No. As a matter of fact, Wall Street Journal wants to get it now themselves. But they sent a whole camera crew to go down and interview the judge. Now, the judge is recently retired. He got cancer of the kidney and liver, and he's now retired. He moved into obscurity. And I was in tears when I found out, and he's got stage 4 cancer now. I told him the last time I spoke to him that he was the finest judge that ever sat on a bench in Michigan. He just was really that good, and we're going to really miss you, Judge. We'll miss your humor. We'll miss everything because you definitely went right by the book. He said, well, coming from me, he really appreciated that and took it for what it was worth because he knew I really cared and I always tried to do good in his court. But the bottom line is you don't find judges like that got that kind of hair on their tail. I'm telling you. And the thing is, when it came down, it was actually a fluke. Nobody planned this thing. It just happened. And see, they were trying to hit this guy Glacier for a big pile of cash because his wife went out to Monkey Warts and charged from the front door to the back door and put it in the front room of his house because they were getting divorced, okay? And she was pissed, okay? Well, then he tried to give it back to Monkey Warts and they wouldn't take it back. So then they were going to stick him for this outrageous thousands and thousands of dollars of bills. So they go to court. And of course, the judge is sitting there, well, let me ask you, sir, did you give your wife this credit card? Well, yeah. So she had your permission to have this credit card? Well, yeah. And she had your permission to use it? Well, yeah. He goes, okay, here's the bill. And he says, now, Judge, you've given me this bill for this thousands and thousands and thousands of dollars, you know. Now, if I asked you for a gallon of something or a foot or a yard of something, you'd say a gallon or a foot or a yard of what? Now you come to me and you tell me you want dollars, and dollars is a unit of measurement, and I'm asking you dollars of what? You see, dollars is defined as a certain quantity of silver, pure and fine, so many grains. And see, we don't have any silver in circulation as a quote-unquote dollar today, okay? So I'm specifically precluded from performing at law, Judge. Now, maybe you could help me. And the judge, as a joke, just a joke, he says, I'll tell you what, we're having a flash and blue light special today. Make it frankincense and myrrh. Or, wait, there yet, we'll make it coffee beans, and you can interpret that any damn way you want. And he was just doing it as a joke, you know what I'm saying? But he didn't realize that he was making a landmark decision. Now, Monkey Wards won the case, so they couldn't appeal, and we damn sure weren't going to appeal, and there was over 40 of us in the back of that courtroom all going, because we realized instantly the judge just made a determination of the money of account of the United States government, and all of a sudden, Judge Sheehy, the light bulb came on bright as day, and he went, oh, shit, and he flipped his pencil up in the air, and the whole courtroom busted out laughing. Now, I didn't know it. Judge Sheehy was golf partners with my dentist, okay? Now, my dentist was a phenomenal golfer, and he almost always won, and these people played for money, big time, okay? And this particular day they were playing, the judge was up on Doc by $300, okay? And boy, this was a first for him for a while because Doc is just that good a golfer. And so he was rubbing Doc raw with this $300. And Doc turned to him and he said, that's all right. I just pay the damn thing with coffee beans. Well, Judge Sheehy went berserk. He took his 9-iron and he flung it around a tree. He took his other golf clubs and threw them in the lake on the, one of those little ponds on the water on the golf course. I'm never going to live that down. I'm never going to live that down. Wait till I see that guy. I'm going to really give him a piece of my mind. Da-da-da-da-da-da-da. And see, all of these little things went on in that community. The next thing I know, I'm running into Judge Sheehy down in federal court, and he walks through the hallway, and we just came out of Judge Cohn's court, who was the chief judge at the time. And he looked at me and he said, "So what do you pay your fines and stuff with down here?" And I said, "Whatever you say, Your Honor, is fine by me." And he goes, because he knew I was going to say coffee beans, and I was going to cite Judge James B. Sheehy, landmark Michigan court decision. So he kind of lost it. So it's like a private joke that's gone on for 30 years here in Michigan. Everybody, if you go into certain areas and you bring up coffee beans to pay the ticket, or if you get pulled over by a cop and he gets a ticket, he says, I just paid a damn thing of coffee beans. Oh, we ain't going there, and he'll tear his ticket up.
That's so great.
But, I mean, this was going on for quite a while. It was a real point of humor in the Patriot community. But, see, we only had a few of those, and I only had 2 of them, and they both got burned up in a fire. So I'm trying to get another one right now, and we got a line on one, and we're trying to get it. I talked to the guy today, and he's going to go through all his papers and see if he can come up with the actual transcript.
That would be great.
Well, if we get it, we'll see. You're going to hear exactly what I told you. Exactly what I told you. That's exactly what I told.
And I just want to say thanks for letting me talk, but I've got to get going.
Oh, well, thank you for coming on. I appreciate it, and for sharing your little information there with your customer that is going to go head-to-head with the beast.
Thanks. I'll see you soon on the next call.
Okay, thank you so much for coming on and giving us your time.
Thank you.
We'll keep him in our prayers, and hopefully he can go.
You're going to need him.
Yeah, I'll keep you posted.
Thank you.
Mm-hmm. Bye-bye.
Bye. So, Constitution, man. You've been quite enlightening this evening. Thank you very much.
Not to worry. Anytime I can help out, you can count on me. I'll do the best I can. The point is fixing it so that people get their honest day.
It's always a pleasure hearing you and learning from you. But we've gone past the 2-hour mark. We're 2 hours and 24 minutes on the recording. We're actually 2 hours and 40 minutes in actual call time. We got a late start, but the chat's been an interesting read. I've been going through that. Do you see the chat, Constitution Man?
I don't get as much time as I would like to go on the internet and do stuff like I do review it as much as I can.
I mean, can you see it right now? I mean, or no?
It's not.
Oh, okay. Oh well, got a lot of people on the call. It's been interesting. I'll give it one more shot. If anybody else, here we have a KL Direct TV. Go ahead. Did you have a question?
Is this Angela?
Yes, it is.
All right, yeah, this is KL Direct TV. I got an easy thing to say to that lady. I heard her last week asking about a 12B62. It's not that her facts aren't stated. It's the other side totally agrees with her facts. It's that she's not bringing the law into the court that she's relying upon, or it's that they're claiming that she's bringing the case into the wrong jurisdiction. They don't dispute the facts in a 12B6. If you could establish the law and if you can establish the jurisdiction, the case is basically over because they can't go back and then challenge the facts.
Right. See, most of the time you don't even get to the position of getting the counter to come back and say that. Because it's done, they stamp, and you get it in the mail, and the next thing you know, you've been summary judgment.
Well, what it is they can't give a summary judgment unless somebody affirms that under oath in open court. That's what that is.
They do that. They'll affirm it on an affidavit of verification, and then the next thing you know, you get a notice in the mail from the court that they summary judgmented you. So it isn't like you're physically there battling. You're not. A lot of times they pull this stunt at the last second, and then they blow you out, and then you have to figure a way to get into either back to court on a rehearing, or you have to figure a way to get to the appellate court real quick before they want to come and foreclose, you know?
You just send back a letter back to the judge relying on Transi versus Pagliaro, which says that they can't make a summary judgment unless somebody came into open court and swore under oath of affirmation that the 12B6 is their claim. Transi versus Pagliaro says that.
Okay.
Right.
Let's say they did that and it was ex parte and you didn't even get notice they were going to do it. What happens then?
If it was ex parte, then obviously you just say that you didn't have a fair hearing. You didn't have a hearing because it was ex parte. The judge can't. There can't be. That's not the final judgment. I'm saying. Then you just say, okay, well that's just the other side's opinion. The other side's opinion is saying that I didn't bring the law into court. Well, Judge, I believe they're in error. I did bring the law into court. As a matter of fact, this is the law. Thou shalt not steal. Now I want a jury trial. I want a trial by jury.
And it was over $20, and I want a jury trial, and I paid my fee.
Right.
Now, I got clients right now that have done everything you just said, and they paid their fee. And they were denied the jury trial, and they went straight to the summary judgment, and they jammed them. And they did it deliberately because the banks in my state are in the hip pocket of the judges in my state are in the hip pocket of the banks, and they do it. Whatever the bank wants, they hold to that presumption. The bank would never do anything immoral or illegal, and they just slam dunk the poor little person, the homeowner.
Well, is it not?
All the time.
Is it not true that all federal district courts are courts of record?
Right. So what we do, we remove the thing to federal court under 28 U.S. Code, Rule 1441.
No. I never use that code because I didn't create that code. I don't have permission to use that code. I don't rely on code.
Okay.
I simply
got people in jail who were thrown in jail because they got in the middle of the foreclosure and they pushed the sheriff off the porch. Okay.
No.
They were in the jail. And I went down to the chief federal judge, and I told him, Your Honor, this matter has been removed to the federal court. And they ignored it at the state court level, and then they false arrested my client, stripped her naked as a jaybird, and threw her in a jail. She had to use toilet paper to cover her private parts. The chief judge himself in front of me picked up the phone, called the sheriff of that county, and said, "It'd be a real good idea. You get that woman out of that jail right now. You got only 10 minutes." And they were down there begging her, "Please come out, honey. We're going to give you your clothes back. No, we're going to let you go." And they let her go, and she got her house, and she got
right. That's a very good. That's great stories. But what I'm saying is, when they submit their claim to the federal court, do they define the nature of the parties in that claim?
Yeah, very clear.
What is the nature of the party if you're helping some plaintiff? If you're helping some aggrieved party, how do you define the nature of them to the court?
Well, they state their jurisdictional claim before the court and show their particular side of it. So the problem is that they deny my guy's side of it.
How do you define your side? What is the nature of the person?
My guy is usually the homeowner who's getting railroaded.
Okay. Is there a reason why the nature of the party, the aggrieved party, why you just don't go and say the nature of the party is a man?
Well, you put that in the brief when we answer it, but we didn't even get served.
Well, I'm saying after you put the caption in there, after you want to put your name in there, that's fine. The caption has no bearing on what's inside the case. So when you get down to the part where you define the parties, is there some reason why you folks just don't say the nature of the parties? Say, I am a man. I am a man as defined by law.
We put that in there, and we also put that you're a flesh and blood, real live man.
That's fine. And then the next part is, why don't you just say that all federal district courts are courts of record, all state courts are common law courts. All common law courts are free to the people.
Well, that may be the way it is in your state, but that's not the way it is in my state. As a matter of fact, in my state, they have disbanded the common law.
Okay. Well, the common law, if you go onto the federal website, there's a federal website, I'll post it, I'll give it to Angela on Saturday. I'll give you the exact link where it says right on the front of the federal website, all state courts are common law courts. It gives you definition of the difference between the federal district courts or if you want to keep your case in a state court. And it clearly says all state courts are common law courts, including Louisiana.
Now, what advantage did you have in doing this? How are you overcoming the 12b-6 in doing this?
The 12b-6 is simple, because all the 12b-6 is saying is they're disputing the facts. They're not disputing the facts. They totally agree with the facts. Right out of the Oxford Law Dictionary, Oxford book from 2002, it says, although judgment is the end product of all litigation, not all cases require a trial. A trial is necessary only to resolve disputed facts. If the facts are not in dispute, the matter in controversy will turn on a question then of law that can be resolved by the judge. But why, and let me finish, it says that the claimant's pleadings do not allege grounds for which the law provides relief, the defending party can move to dismiss the case, sometimes called a demurrer, with a motion of 12b-6. But
that's another thing in my state. They have abolished demurring. You can't demur anymore.
Right, so it's called 12b-6 now. So that's fine, but it says the question of law can be resolved by the judge. Now, when you go into a court of record, who is the judge?
Well, that's a good question. I often ask that myself, because a lot of times the judge is acting like the attorney for the other side, and we have to get that verified. And I say, excuse me, Judge, who is the attorney for the bank here?
A court of
to that guy right there, and I said, okay, who's the trier of fact? Who's the disinterested trier of fact? He said, well, I am. I'm the judge. I said, well, I'd really appreciate it, Judge, if you're going to try this case as the judge, that one, you'd go for a win, and two, that you would let that attorney do his own pleading and practice before this court. But if you're going to be both the attorney for the bank and the judge, I'd have to object to that, Your Honor. May it please?
I'm not saying exactly for banks or mortgages. I'm saying all federal district courts are courts of record. The judges in a court of record are the 12 jury people sitting in front of you. Where does a judge sit in a court of record in the federal district court? Have you ever walked into one?
Yep.
Where does he sit? The guy in the black robe.
Sits right in the middle of the wall, of the back wall. The jury sits usually impaneled in a jury box to his left.
Right. The judge sits behind you, behind the plaintiff and the defendant, or he sits to the extreme left. The judge does not sit in front of you like all you folks are picturing on your movies.
You haven't been in federal court in Detroit, because I'm telling you, they sit right in front of you. Dead square in the middle of the room, there's a huge golden eagle on a marble wall, and they sit right
then you are not in a court of record. Then you're in a civil court.
Well, you can do all this stuff you want, but when they issue a judgment from that court, guess what? Things happen.
But as a civil, you don't go into a civil court. You go into a court of record under the common law. You file a tort claim. You don't file a civil action. You never use a statutory code because you go wake up tomorrow and at midnight they change all the codes on you. So you walk into court the next day and your codes mean nothing because they're not your codes. You're not a party to them. You're not allowed to use them.
But you know something? They have court rules that they hold to, and one of those court rules, they call it the Federal Rules of Civil Procedure, and that is in a code, Title 28. Now, the bottom line is that is the court rules for the federal court. And if you're the very fact that you cited 12b-6, that comes right out of that same code.
That's why I say it's similar to a demur. When I filed my claim, I said if they choose the demur, which is similar to civil code 12b-6, I never, ever use their code. I just say it's similar to your code.
I understand about traversing. I do understand about traversing. But the bottom line here is you need to understand when we get to that court, they're going to make some decision, for sure, okay?
Who's going to make a decision?
Depending on how we handle it, depends on whether my client stays in her house or she's...
I'm not talking about houses. You keep bouncing the houses. I'm not talking about that.
That's mainly what I do, houses.
Okay, that's fine. Well, all I'm saying is if somebody wants to move a claim into the federal district court, they have to make sure as soon as they fill out the caption, put their names and say this is a chosen action, say it's a trespass on a case, then the next thing they want to put down is the jurisdiction, and then they just say there's a controversy between the parties in excess of $20, and I'm relying on a jury trial for the Seventh Amendment based upon...
I demand a jury trial.
What's that?
I demand the jury trial.
You could demand it, or you could do it in the common law terms, and you can make a wish. You say, I wish for a trial by jury.
No, I demand it, and we pay the fee.
Well, I don't pay the fee. That's why I don't pay the fee, because I am moving in. I'm letting the judge, giving the judge notice that I am coming into a court of record. That first I said to him, "Is it not true that the federal district courts are courts of record?" He'll say yes. Is it not true that all state courts are common law courts? Yes. Is it not true that a court of record is free to the king and to his subjects to access? Yes. Am I not either the king or one of the subjects?
Well, you can try this line. I can tell you, in some states you might even get away with it, but I can tell you, in 3 states you won't get away with it. One is New York, one is Michigan, and one is California. And the reason you won't is because this guy who taught at Heidelberg University, my mind is a little tired tonight. I've been jumping through my ass since 4 o'clock this morning here, but he's the one that taught these people from Michigan, California, and New York that the citizen exists for the good of the state. It's the state that makes the decisions, and the citizens just should live by it. Hegel is the guy's name, okay? And all of the students that went to Heidelberg University came from Michigan, California, and New York. So when you get into these states, it's very, very socialist. And these people in these states, they're very avant-garde. And they have the best militias, and they have the best group of patriot communities, and they have the most pro se litigant attorneys, and the system here is wound tight. And when you walk into these courts and go through all of this technical mumbo-jumbo, I'm going to tell you a secret. In Detroit, you will get killed. They will just wipe the floor with you. And the reason is because they'll say, just a second, Sonny, I'm the judge here. You see anybody else here wearing a black robe? And well, no, Your Honor, I don't. So that kind of means I'm the boss, huh? Well, yeah, that's the way it is. And I'm going to run this court the way I want to run this court, not the way you want to run this court. And then they're going to, from that point on, you're not going to get much of a listen. You're going to lose a whole lot of latitude by going into these type of arguments and technical merit, what I call jibber jabber, because what's going to happen is the judge, if you give him a ration of shit and you start arguing jurisdiction, you'd better have some court cases to back them up. You better be able to argue Title V, Section 556D as in David. The proponent of rule or order has the entire burden of proof of all claims made. Now, I'm not the one that brought this complaint, Judge. This guy here from the bank or wherever brought the complaint. He hasn't proven jack. He hasn't even demonstrated jurisdiction. The second thing is, McNutt versus General Motors Acceptance Corporation and Higgins versus Levine very clearly state that once jurisdiction is challenged by any party, that burden must be proven timely, and failure to prove it timely, laches incurs, and you are stoked from proceeding by laches, okay? Now, these guys don't ever answer the pleadings, number one. That's something you really need to know in Michigan. They don't answer. They'll ignore the living shit out of you. Their attitude is, you're just a peon. You're lucky I'm even talking to you. And you don't even have a suit on with wingtips. You know what I'm saying? So when you go into all this technical merit stuff, all you're going to do is piss that judge off to a point where he's probably going to sanction you if you open your mouth one more time. And I've actually seen it happen where they told the guy if he opened his mouth one more time, they taped his mouth and chained him to the chair. You're not going to put these judges on trial in their own court. It ain't happening.
What I'm saying is I never go in as a pro se litigant. Why would you want to be a pro se attorney?
Because you can't find an attorney, because there aren't an attorney that's got balls enough to even try this stuff.
But if you define yourself as a pro se attorney, then you're going to be held to you're going to be to the same rules and standards.
And hold you to the same standards. That's Haynes versus Kerner, 404 U.S. 519.
That's a lay litigant. It's not a pro. It's what I'm trying to say is, why don't you just go in as a man and say, I don't move under your codes, and I'm not going to hold court.
It's a good idea. It's a good idea. I have other guys that try this stuff where they walk up to the bar, but they won't pass the bar.
No. You do it all in writing. I never say a word in court. I would never be crazy enough to argue with somebody in court. I don't speak the same language.
Then how do you get relief?
How do I get relief? I create the orders, and then I just have the clerk of the court pass them over to the other parties, serve them through the U.S. Marshal Service. If they want to appeal it, they know how to appeal it.
Let me ask you a question. Did the judge ever ask you who you are? Who are you?
I'll go right to the head judge. I never speak to the man in the black robe in front of me. When I go into a court of record, it's only a magistrate that appears, and that person sits behind me or to my extreme left. They're totally out of the picture. My judge in the court of record are the 12 people sitting in front of me. Those are the ones who only make the decisions. Nobody else is allowed to make a decision.
This may work in a patriotic meeting or on a talk show. Okay.
No,
I don't believe it would work in a real court. Truthfully, I don't.
If you'd like to,
the first thing the judge is going to say is, "Who are you?"
Not the judge. You don't say.
You don't give your appearance, and your appearance is going to depend on whether or not we listen to you any further. So you're going to have to tell them who you are. I am so-and-so, and I'm here before the court as a pro se litigant appearing in appropriate persona, and I'm here on a special appearance as distinguished for a general appearance because out of respect for the court and courtesy to the court, I want to at least be able to state some truth of the matter. And then you shut up and let the other guy give his appearance.
I guess that's what you would do if you were going into court. I think what he's saying is he handles them on paper.
Now what happens when they drag him into the court?
I don't know. What happens when they drag you into the court, KL Direct?
Okay, they don't drag me into the court. Like I said, I submit my claim. And when I submit my claim, everything's done on paper. Most times, like I said, I can't imagine why you'd have to physically appear into the court if the other side fails to respond.
Here, because there's these 6 big guys that are holding you very tightly, and they've got 2 sets of handcuffs on you, and they physically tell you that if you even flinch crooked, they're going to bust your nose. Okay.
What I'm saying is, when I file a lawsuit, when I
charged with years of income tax violations. Now, what do you want to do about it?
When I'm the aggrieved party, when I'm the plaintiff, I'm the one moving to court. They're not dragging me into court. I'm trying to drag the defendant into court.
I see. All right. I respect where you're coming from. So you are the plaintiff, in theory.
I'm the plaintiff, right? I'm always the plaintiff. Why should I ever be a defendant? That doesn't make.
Because sometimes you get charged with BS cases that are nothing but a harassment to screw with you because you're out helping people do this stuff, and we don't like you.
So then why don't I just turn around and see, because when you enter into their case number, like if they have a case and they have a case number generated by the court, and you make any kind of answer, then you're accepting their belief that you really are part of their case. If somebody hands me a case number, if somebody hands me a document with a case number on it and they want to bring me in there, I immediately file my own case. And then I drag them into my case number. I use my law and say, who are you to make a claim against me? Under what jurisdiction, under what delegation of authority do you claim to have the right to move me? Because I'm a man. And only a man
What happens when you do this? What happens when you do this?
What happens what?
What happens when you do this procedure?
The other side just gives up. And especially if it's the state, or especially if it's the county, or especially if it's a traffic ticket. You just say, but you file your own case, and you can't operate under their law. You can't operate under their case number.
So what do you do with their case number when their case number calls you to court?
You say, I totally agree with all the facts, but that's the facts, but the law does not pertain to me. I agree with all your facts. I did 3,000 miles an hour. I was doing it on my roof. I was going zigzag all over the road. I don't dispute the facts. But what law are you relying upon? Because I don't recognize your law. The only law I recognize is that either I injured a party, injured a man, or I breached the contract.
We have a problem here. In Michigan, if you did that, that judge would just have you in for a psychiatric eval.
Did you ever file your own case, or do you always answer to their case? I never answer to their case. The only answer I give to their case, I don't dispute anything you're saying, but what authority?
Me 6 times, so I know they will do it, okay? Now, they don't do it anymore because the last time I beat the hell out of them so bad they don't even want to talk about it, okay? But I'm telling you, if you get too avant-garde with a lot of this technical merit argument, like going right to the bar but don't cross the bar, only to have the judge tell the bailiff, go out in the hall and call Mr. So-and-so, and you're sitting there right in front of him, and he knows it's you, and he'll have the bailiff go out in the hall and call your name because you won't come before the bar. Then he's going to declare that you weren't in the court that day, and he's going to enter a default judgment against you for failure to appear, okay? Now, I've actually sat in court and watched judges do this crap. This idea that you're not going to show up and go before the bar and argue your case, it's not going to happen in Michigan. You're going to go to jail, okay? That's just the way it is. I don't know how it is in the other states as much, but in Michigan, they don't let you get away with pulling all of this wild and crazy argument stuff like they do at the pro se meetings or the constitutional meetings. They don't let you get away with this stuff. I know. I used to conduct the meetings. I used to help people pick a jury. I used to help them file their papers. I used to help them do all of these things. I know what you're going to get away with and what you're not going to get away with. And if you don't come into court and act like a perfect gentleman, show that you're a non-combatant, that you have dignity and courtesy toward the court, you're going to get killed. I just had a guy do it last week. He wouldn't stand for the judge. The judge came in, the bailiff said, hear you, all rise. And this guy wouldn't stand. And the judge gave him 6 times to stand, and he wouldn't stand. And he had actually won his case on paper. He had won his case on paper. I know. I helped him do the briefs, okay? And he belongs to a specific Muslim faith that doesn't believe that a man should stand for any other man. The only thing you stand for is Allah or God, okay? And so on religious beliefs, he chose not to stand. Well, after the 6th time the judge gave him a chance to stand, he held him in contempt, threw him in jail for 30 days. And he'd already had the case won on paper. Well, that's what
did he say something to the guy? Did he say, are you going to stand? Or how did he go about doing that 6 times?
Are you going to stand or what? And he actually warned him, if you don't stand, I'll hold you in contempt. And on the 6th time, he ordered the bailiff to take him into custody and threw him right in jail.
That doesn't mean it's right, though.
I'm not saying that, but I'm telling you that's what happened. You understand?
Yeah.
There's what's right and there's what's happened. There's an old saying that says you can be dead right.
Yeah.
But still dead.
Yeah.
So,
well,
I'm telling you,
if
you jam these guys on their procedure, on their court custom and usage, on their, and I said to the guy, I said, well, let me ask you. I said, your wife wears this veil on her head, right? And he goes, yeah. I said, why? I said, because it's a Muslim custom. I said, okay. And she does that as an act of her faith, right? Yeah. I said, well, that's your custom, okay? And you would defend her right to do that to the death, right? Oh, yeah. Now, do you understand that judge has his custom and his usage and what he's used to? And what he's used to is when he comes into the court, when they announce the court coming to order, everybody stands. And if you don't stand, he's going to hold you in contempt. I made the guy write a letter of apology to the judge. This is just a misunderstanding, a simple misunderstanding. It's my religious belief that you're not supposed to stand for any person but God, okay? And the judge actually thought about it for a second, and then he cut the guy some slack, and he pulled back the judgment and let the guy have his day, okay? But he didn't have to do that. Do you understand? But once he understood that it was a serious religious matter and that this was a personal belief, a conscience belief, pursuant to U.S. versus Cheek and U.S. versus Cruikshank, where you honestly and truly believe in your heart of heart this is right, well, okay, I'll give you the benefit of the doubt this time, but the next time you come in my court, you know the custom, you have to stand, okay? Everybody has to stand. That's the rules, okay? So if he goes back in that court next week and he's going to be in the same position, and I told him, you want to know something? You're right on the edge of a major conflict here between two cultures. And you have your culture and your beliefs, and they have their culture and their beliefs. Now, you got two choices. If you don't mold a little bit, you don't get your chance to say your piece. And if you don't get a chance to say your piece, you're going to get found guilty. Because if you get the chance to say your piece, you're going to win. Because they haven't got one argument that will be able to go against you. So what do we do here? This is a serious decision. You're going to have to weigh the facts that you're going to stand out of just custom, like when you're in Rome, do like the Romans do. And you're just going to stand and be courteous as hell to that judge, and then you're going to get a chance to argue your case, and then you're going to argue your case, and you're going to beat the snot out of the other side, and then we're going to get this whole thing over, and your name's going to be cleared, and we're going to walk out of here victors, and you're not going to have to worry about this anymore going to jail. Now, you want to do it my way, or you want to play games? Because if you want to play games, I'm telling you what's going to be the end result. You're going to jail.
Well, we're going to have to end it at that, if you don't mind. We've gone 3 hours, and my son is staring at me, giving me dirty looks. Okay. So, thank you so much for coming on the call, Constitution Man. I love it when you come on. I appreciate your time and energy, and I know you're so busy. And I think when you come on the call, it's a way for you to unwind a little bit, huh?
Oh, I do, and I enjoy helping people advance to a higher standard of learning to where they actually do get their day in court, where they actually do get listened to, where they actually do, they can actually say, hey, I got my day in court today, And then I had this one woman, I'll never forget her, walking down the highway, she beat the snot out of the best trial lawyers in Southfield, Michigan, and she said to me, tears coming down her cheeks, she says, I think I got my dignity back. I says, yes, you did, baby. You whooped them real bad. And, of course, they wouldn't even look her in the face.
Oh, that's wonderful. I'll bet she felt 10 feet tall.
Really good. Now, that to me is serious payment. That to me shows the little person got their day. And that's my interest. The little person got their day. And with that, I'm going to wish you a very good night. Thank you all for the opportunity and to be here. And just know that I'm out here doing the best I can to throw every wrench I can on these rats.
Well, thank you so much. I appreciate it, and I'm glad you're there. A lot of people need your help, and I know you can get to them as time permits, but you need to rest up, too, and get some downtime. So you need to take the wife on a vacation or something.
Yep, we're talking about that right now as you speak.
Good. All right. Well, have a good night, Constitution Man. Thank you so much again. Thank you, Missy, if you're still out there, for coming on. I appreciate your time and effort also.
Thank that gentleman, too. I appreciate his staunch defense. I do.
Okay.
I do appreciate it.
I do, too. Kill the Illuminati. Thank you so much. One time, and you can get everything you have all off your chest. It was a little interrupting there, a bit interrupting, I should say, but no. I'm reading the chat, but I gotta go. I love you all. Take care. We'll see you next Thursday. We'll see you Saturday on Jack's call. He's going to have a woman on. I forgot her name already. Geez, and I just put it on his ad on his webpage. But anyway, we'll see you on Saturday morning with the Protectors of Liberty call. And then Saturday night with Jack, and then Sunday with John Stewart. And we'll start all over again on Monday. I love you, everybody. Take care of each other.
Now who needs a vacation?
Really. Good night, everyone.
Good night.